Good morning, all. This hearing is in the matter of CFI 030-2023 and is being held by way of video conference before Justice Andrew Moran, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Al-Hajji Al-Nubi Advocates and Legal Consultants. Lead counsel is Ms. Asha Bijoy. The defendant is represented by Lex Ensemble. Lead counsel is Mr. Santanu Ghosh. Thank you, Your Honor.
Thank you very much, Alia. Well, good morning, Mr. Ghosh and Mrs. Bijoy. There are one or two preliminary matters that I need to deal with before we resume the trial, not least in terms of directions as to how we shall proceed. There is, first of all, an objection to the 7th and 8th witness statements of Shakti Chauhan, which were served without permission and not in accordance with my directions, and they have been objected to. However, as with certain other rulings I have made in recent days and weeks since the trial had to be adjourned, this filing seems to be more as a result of, I will put it as kindly as I can, unfamiliarity with the rules and procedures. And I am not clear what difficulty you face, Mrs. Bijoy, in dealing with these witness statements beyond that. You have, it seems to me, the necessary witnesses available to respond to what is said in them. You have had notice, in effect, of what the cross-examination will be of your witnesses when they are recalled, depending on which of them are to be recalled, and that I will deal with in a moment. I have admitted evidence filed in breach of the rules of the court, of previous case management directions, and of my own directions in the interests of justice, only because I was satisfied that the claimants were not prejudiced by the late production and admission of these materials, very much in the same way as I felt obliged to adjourn the trial in order to have all of the relevant evidence before the court to make a fair and just decision. Now, I will hear your objections, Mrs. Bijoy, orally, in addition to what you've already said in email correspondence, which obviously I've taken account of. I've given a very stern direction by email of the 4th of July, timed at 09:49 British Summer Time. I'm sorry, that was to the registry, that email. You won't have that. There was a direction issued after I had written to the registry saying the court has considered the claimant's objection to the filing of the 7th and 8th witness statements of the third defendant, which were filed in breach of the court's order and without permission. I'm not going to read it all because I know it was conveyed to you. And I gave a direction that there be no further filing, since it seemed that the defendant's counsel was under a misapprehension as to liberty to file almost at will. That has been corrected and will not occur again, I am confident. So, Mrs. Bijoy, do you still maintain your objection to the admission of the evidence contained in these witness statements, bearing in mind that when you put your case to Mr. Chauhan, he is going to respond, one would expect, in the manner and tone of those 7th and 8th witnesses. So it's going to come into evidence in any event, it seems to me. Do you gainsay that proposition?
Yes, Your Honor. So, of course, my position is that because of the additional witness statements that has come in too late, we did not get sufficient time to go over it and prepare a reply. So as long as if the witnesses can be called back and the necessary questions can be put to them in terms of seeking the additional clarifications, especially these clarifications would have to come from Mr. Dhruva and from Mr. Dino. So if I am permitted to do that, I believe we should be able to I would be happy to accept the addition of these additional witness statements, Your Honor.
Well, you will be able to do that because I'm going to make it clear for the umpteenth time to Mr. Ghosh, it is his duty to put his case. When these witnesses are recalled, and as I say, I want to know precisely who is going to be recalled and in what order in a moment. I'll come to that in a second. When these witnesses are recalled, Mr. Ghosh is under a duty to put to them essentially what is in Mr. Shakti's fourth witness statement, and no more, and no more, and what is in Mr. Shakti's seventh and eighth witness statements. This trial, these witnesses are being recalled for a very limited purpose. That is to put to them matters that ought to have been put in evidence before the last trial, before the trial started, in accordance with the evidential directions that had been given. The evidence was not put in, the case was not put to the witnesses, which stems from these documents and evidence, and I am allowing the witnesses to be recalled only, Mr. Ghosh, only for the purpose of you putting to them the new materials that you produced in the last hearing and produced subsequently in excess of the permission I gave, but I've ruled that they shall be admissible. You will put those matters to these witnesses in cross-examination in accordance with the rule in Brown and Dunn.
Yes.
Mr. Ghosh, can I just be clear? You are absolutely you absolutely understand the rule in Brown and Dunn, do you? And the obligation to put your case, your client's case, on these matters. You do.
Yes, Your Honor. Yes.
Thank you very much. Well, I'll travel in hope that you will abide by its principles religiously as we go forward. So,
yes.
Mrs. Bijoy, on that basis, what will happen is that Mr. Ghosh will put his case, his extra case, if I can call it that, to your witnesses when they are recalled in cross-examination, and you will have a full right to re-examine those witnesses on those issues which will, on my directions, be put to those witnesses. So that is, I think, the first matter dealt with. I will allow the witnesses to stand as written evidence in chief on these additional issues which have been produced late in the day. And Mr. Ghosh will put the matters in those witnesses to the witnesses who will be recalled for the claimant to deal with these additional materials and this additional part of the defendant's case. Are you content with that, Mrs. Bijoy, or do you have any submissions to make?
Yes, Your Honor. So if I may please make a submission that because we have not had an opportunity to file a proper witness statement addressing the new issues that are being brought in witness statements number 7 and 8, it is my humble submission that I may be permitted to take the witness in a chief examination to bring in those clarifications based on which Mr. Ghosh can then do the cross-examination.
Well, yes, I hear that application, and it is one that is understandable, but I'm not sure it's necessary. I'll hear Mr. Ghosh on that and see what he says. Because if he does his job properly, it should not be necessary for you to lead evidence in chief in response. Your clients have had notice, and in addition to that, I, of course, have to weigh all of this evidence, and that includes a weighing of it in all of the circumstances, in full knowledge that you did not have enough time to put in responsive statements to the 7th and 8th statements. But we cannot go on forever in a ping-pong cycle as it's sometimes called, of filings and counter-filings. As Mr. Gosh inappropriately put it, rejoinders, surrejoinders, surrebuttals, rebuttals, surrebuttals. I know how far it can go. That does not happen in modern times and will not happen in this case. But I have your application. You wish, therefore, to take your witnesses who are recalled through the additional matters only in the 7th and 8th statements, because you did have an opportunity to reply to the 4th statement. And there are statements from Mr. Skandalis and Mr. Acharya dealing with what is in the 4th witness statement. That is right, isn't it? And you also have filed an amended reply to the defense, which I have, based on what is in the 4th statement. So this is purely, what you're seeking is purely to deal with the allegations that are raised in chief in the 7th and 8th witness statements without the filing of a witness statement from which witness do you want to call to deal with that? Which of your witnesses do you want to lead in chief in response to statements 7 and 8?
I would prefer to call Mr. Acharya, Your Honor.
Mr. Acharya on those issues, right?
Yes.
Okay. So you only want to lead Mr. Acharya in chief, not any other witness.
Yes, Your Honor.
Right. Okay. Well, there you are, Mr. Ghosh. Do you have any objection in these circumstances where really this is all down to you against Mrs. B. Joy asking some questions in chief of Mr. Acharya to respond to the 7th and 8th witness statements of Mr. Shakti Chauhan?
No, Your Honor, I cannot possibly have an objection to that.
Very well. Very well. Well, that's helpful and constructive. Well, I will give you that leave, Mrs. B. Joy, to ask questions in chief of Mr. Acharya, exactly therefore and we'll do that shortly. But can I be clear? This is for you, Mr. Ghosh. You've produced these new materials in the course of the last trial and subsequently. Which of the claimant's witnesses do you wish to have recalled in order to properly put the defendant's case to them? Which witnesses? So you've got Mr. Sami, Mr. Skandalis, Mr. Acharya. Do you require them all to be recalled to put your case, or just one of them, or what?
Mr. Skandalis, I believe, would be the most appropriate person because he had signed the financial statements also, and he had comprehensively replied also. And,
right.
But I mean, Mrs. Asha brings Dhruva also, obviously, with respect to the 4th witness statement of the defendant number 3. And then I will also cross-examine him. But the questions are very limited, Your Honor. So I've also conveyed to Mrs. Asha that I will not take much time for even if there are more than 2 witnesses from her side, it will not take much time.
Oh, very well. You've heard that. You intend then, let me be clear about this, all of this evidence about the Vingold transaction, because that's what started it all really, and then you produce documents, the signed promissory notes as well. I'll use those as an example. You intend to put the case founded on those documents to Mr. Skandalis, is that right?
Yes.
And you don't seek leave to cross-examine any other witness on those issues apart from Mr. Skandalis. Obviously, Mr. Acharya deals with separate matters.
Yes.
And he is being recalled and being asked questions in chief, so you will be at liberty to cross-examine him on those matters which he is able to deal with and that you ought to put to him as part of putting your case. But there's nobody else. You're not making an application then to cross-examine Mr. Sami further or Mr. Garg further on these matters. Is that right?
Yes, because in the inception only on the first day when we started this trial, Mr. Sammy, I mean, he himself said that he was not very well aware of the day-to-day thing. So I don't think it will be any use to bother him much on this.
Yes, very well. Well,
and if Mrs. Asha brings, there is a witness statement of Mr. Garg. I'm not very sure relating to which I have checked it once, but if he's coming here and making this witness statement, filing it as evidence, then I will have the reserve the right to cross-examine him if he's coming.
That witness statement stands as evidence in the case. If you don't want to cross-examine him, that is unchallenged evidence in the case. So just remind me, I've lost track of the numbers of witness statements. Is it Mr. Garg's third witness statement that we're talking about here?
Yes, Your Honor.
You've lost track as well, have you?
Yes.
Right. Well,
no, in that case, Your Honor, if that evidence is unrebutted, then that might prejudice the defendant. So maybe 2 questions from that witness statement will be required.
Well, I was surprised when you said that you didn't want to cross-examine Mr. Garg, because the matters that you have raised relate to evidence that he gave about the Vingold transaction and also the promissory notes. So you might want to put your case to him as well. So it seems, therefore, that all witnesses are going to be recalled, save Mr. Sammy. Right. And then the order in which we're going to do this, it seems to me that if we're having some evidence in chief, we ought to have it from Mr. Acharya first, then Mr. Skandales to be cross-examined, not in chief, and then Mr. Garg to be cross-examined and not in chief. Cross-examined and re-examined, I should say. So right. Now, then, whilst we're talking about timetable, bearing in mind the indications I've been given just now by Mr. Ghosh as to the brevity of his cross-examination, we will then resume cross-examination of Mr. Shakti. Is that correct, Ms. Bijoy?
Yes, Your Honor. We will continue with the cross-examination of Mr. Shakti.
Very well. And then, you see, we haven't got a trial timetable for this phase of the trial. I'm not criticizing you with all else that's been going on. So, Mr. Shakti, then Mr. Fakhran.
Yes.
Who will be cross-examined. There will be no evidence in chief because he has put his witness statement in. He will be cross-examined and re-examined. And then we are, am I right, at expert evidence?
Yes.
Your Honor, in that regard, the expert is not available until Friday. So if we can place the expert evidence first thing on Friday morning, that would be highly requested for, please, because I was told that the expert availability for Thursday afternoon, I can reconfirm during the proceeding today, or for Friday morning, Your Honor.
Well, I think on the basis that we've just been discussing, we're going to get to him on Thursday. So he's a witness in this case. I allowed him to replace the previous witness. He will be here when required. he'd have to have a very, very good reason not to be here to follow in sequence after Mr. Fakran. So I leave that in your hands. You've got a team there behind you. You can impress that. This trial is not going to be delayed any further on account of witness unavailability, especially when I allowed this witness to be substituted for the previous expert witness who was not available on these dates of reconvening of the trial. So I trust your colleagues are listening to my words on this, and while we proceed with the trial, are taking steps to make sure that the expert is waiting in the wings, as they say. Very well. So, Mrs. Bejoy, do you wish to begin then by recalling Mr. Acharya, taking me to his statement? Final matters, just for your information to be absolutely clear. I am now using 2 bundles. The second bundle that was filed shall be named the supplementary bundle in accordance with my directions. It's a bundle of 598 pages. So any references in that bundle shall be to the pagination, the electronic pagination in that bundle, supplementary bundle. I am also using the original, I've called it the new trial bundle, of 1,343 pages, which is the bundle that was filed for the last hearing without the addition of the skeleton arguments and so forth. And the reason for that I explained to you at the time. I had worked on that bundle, annotating it, highlighting it, and so forth. So all the page references in that are the same as they were before. And when you refer to skeleton arguments and such like that are grafted onto that bundle after page 1343, that is not a problem because I have all of those documents printed out and I'm using printed copies of them. So that should facilitate the administration of the trial going forward now with that knowledge. And there we have Mr. Acharya ready for action. He's now on screen, so we will proceed from there. Good morning, Mr. Acharya. You are going to be asked some questions, first of all, by Mrs. B. Joy. First of all, I remind you that you have made an affirmation to tell the truth, and you are bound still by that affirmation. It continues to have binding effect. You do not need to be the subject. You do not need to affirm again, but as long as you remember that that is the position.
Your Honor, okay, Ms. Asha, you may continue.
Your Honor, just to confirm that we are continuing with Mr. Chauhan's cross-examination today, or are we starting with the chief examination of Mr. Acharya?
Yes, we Mr. Chauhan's cross-examination, I've just sketched it out to you. Mr. Acharya, Mr. Skandalis, Mr. Garg, then back to Mr. Shakti Chauhan, and then Mr. Fakran to be cross-examined as well. That is the order of play, as it were. Do you have any comment on that, Mrs. Bijoy?
Your Honor, just for clarification, so we will continue with the cross-examination of Shakti today, followed by Mr. Fakran, and then we will have the chief of Mr. Acharya, cross-examination of Mr. Skandalis.
No,
that's not okay. So we will go with the claimant's witness first.
We are dealing with what ought to have been done before I had to adjourn this trial. We are trying to put the matter back on the rails. So we deal. I would have thought that would have been absolutely clear and obvious, so that Mr. Shakti's cross-examination is conducted on the basis of the evidence that would have been before the court, ought to have been before the court, properly before he gave evidence. I am trying to restore that sequence of propriety in the conduct of the trial. Does that make sense to you?
Yes, Your Honor, it makes absolute sense to me.
Right. So Mr.
Sorry for the
Acharya,
confusion.
Mr. Acharya is going to give evidence first, confined to the matters which have arisen since the trial had to be adjourned, and he has made a further statement, but he has not been able to respond to the 7th and 8th witness statements of Mr. Shakti Chauhan, and you are going to ask him questions in chief about those statements, and he will then be cross-examined only on the new matters by Mr. Ghosh. It's not a rehash of the rerun of the cross-examination opportunity that he had earlier. Is everything clear to everybody, please?
Yes, Your Honor, yes. And one more thing before we start, I had a discussion with Mrs. Asha regarding the closing submissions, because I mean, so many evidences come in now, and personally also I've been not keeping well in the last 2-3 days. So if we can file written submissions by Monday instead of oral submissions, if that helps.
Mrs. Bijoy, what is your view on that? Written submissions.
Your Honor, maybe we can have a brief closing, which does not exceed maybe 30 minutes, just to take you through the main points, followed up with the written submission, a detailed one.
Well, let's see how Mr. Ghosh is feeling after the evidence has been given over the next couple of days, and I'll make that decision on the basis of how things appear to me at that time.
Your Honor, before we start, by way of housekeeping, can I just take a moment, a small recess, to let the other witnesses know that they will be in the line soon? Because
yes,
of
yes, you can. Just give me the page referenced in the supplementary bundle for Mr. Acharya's statement, and I will have that up ready to go.
Actually, both of us were under the impression that we will continue with Shakti's cross-examination.
Yes, I also had to rush. I'll just get my charger, and then I'll also reconvene in 2 minutes.
Your Honor,
Right.
it would be helpful if we could please request for a 15 minutes recess, if that is...
Yes, I'll give you, but before you go, just give me the page reference for Mr. Acharya's statements.
It's 576 in the bundle, Your Honor. 576 in the bundle.
576.
Yes.
Yes, I have that. Thank you very much. Right. I'll adjourn for 15 minutes to where you are. It'll be 11:45.
Yeah.
Whilst we're trying to overcome these technical difficulties, there was one other matter that I wish to speak to you both about as the advocates. Now, his camera. Are you there, Mr. Acharya?
I am. I'm just trying to work this out. Otherwise, just log in from my mobile phone. Oh,
there you are now. Yes, we can see you now.
Okay.
Actually, I'm going to ask you to hold for a minute because I've just wanted to mention something to counsel. This relates, Mr. Ghosh and Mrs. Bijoy, to the issue, which is also for trial in these proceedings, which is issue 1C. What is the effect of signing the shareholder resolution dated the 31st of December 2020, and what are the obligations of the parties therefrom? I think that obviously means arising therefrom. I had made observations about the scope of my determination in the first hearing of that issue, but I have reviewed all of the evidence that's been given about it, and it seems to me that what this issue is requiring me to do is to formulate declarations as to the effect of the shareholder resolution and of the obligations of the parties arising under it. And I may have given an impression to the contrary, but if I am right in that thought process, and you have no objections to it, I'm going to require from you in your submissions a formulation of the directions that you seek. So, for example, if I am to make a declaration of the effect of the shareholder resolution, you would need to make submissions as to what that declaration should be. And likewise, a declaration of the obligations under the shareholder resolution. So the obligation, for example, and I'm not deciding anything about this, that Mr. Snyder Prime were under an obligation to introduce gold capital of 100 kilograms, and until they did so, no dividends would be paid to Mr. Chauhan, Shakti Chauhan. So that is the sort of form of declarations that it seems to me that this issue 1C requires.
Yes, Your Honor. Yes.
Do you agree with that, Mr. Ghosh?
Yes, yes. I had already formulated that. I mean, for my closing submissions. Yeah.
Right. And Mrs. B. Joy, likewise, do you accept that that is something that that is the approach that I ought to adopt in order to deal with issue 1C?
Yes, I agree with Your Honor.
Right, that's very helpful for you both. I'm sorry to, I should have dealt with that as a housekeeping matter, but I thought I would deal with it now while we were having technical difficulties, now happily resolved. So we can.
One more housekeeping thing to discuss, Your Honor. I apologize for bringing this too late. We have discussed about the cost to be reimbursed by the defendants. We have made an application, but the cost has not been reimbursed. When we place the request, there has been challenges raised on the cost submissions on the grounds of reasonableness.
Yes, well, I can understand that. I have more than enough to be dealing with at the moment than costs. Issues of costs will be deferred until I decide that I'm in a position to deal with them. So don't be expecting that to be dealt with as things stand at the moment. Yeah, let us move. Let us move on. Right. So, Mr. Acharya.
Asha, you want to lead me into a question, or should I just talk about my business?
No, Mr. Acharya, you are there to answer questions, not make speeches. Please remember that.
Got it. So
Mrs.
just to be clear, Your Honor, am I responding to my third witness statement or Wingold?
You are going to be dealing with both, and Mrs. B. Joy is going to be asking you some questions about a statement that you've not responded to yet, and she is confined to that. Then you will be cross-examined about the matters that you have responded to, the Vingold and the promissory notes, that sort of thing. You'll be asked about that by Mr. Ghosh to begin with, and then re-examined by Mrs. B. Joy if she sees fit. Very well. So, Mrs. B. Joy, please proceed with your questions.
Mr. Acharya, if I may please refer to the supplementary page bundle, page reference number 227 until 230. I see a witness statement. Can you confirm to the court that this is a witness statement that you have submitted as part of the proceedings?
Can you tell me by section, Asha? I have my notes as per section in the case bundle.
Section. Okay, just give me I'll just locate the section for you. Section E in the supplementary bundle.
Okay, section E.
Page number 227.
Yes, that is my witness statement, yes.
And on page number 230, that is your signature.
Yes, that is my signature.
Okay. I now refer you to another reference in the same bundle,
Oh, just wait a minute. Are the contents of that statement true and correct?
Yes.
Mr.
Yes,
Ansari?
Yeah. Ms. Ajari, yes.
Yes.
Thank you.
Thank you.
Mr. Ajari, if I may now refer you to a witness statement submitted by the defendant in the proceeding, which is starting from page number 556.
Can you tell me the again section wise, please?
Yes, just a moment, please. It is section I.
Section I. Okay. This, and I'm looking at
Page 556.
it. This is okay. Perfect.
556 running up to page
Understood.
number 560.
Yes. And in fact, Your Honor, this is response to my response to Wingold.
Yes, I was going to ask you that question.
You're just being taken to this statement to identify it because you have responded to this in your third witness statement.
Yes.
And you're not going to be asked questions about your third witness statement. That is your evidence in chief, right? Mrs. B. Joy, continue.
Yes. So as you may note, this is a reply witness statement submitted by the defendant in response to your witness statement that we found on page numbers 2272 to page number 230 in the supplementary bundle. Now, I would like to seek your clarification on a couple of paragraphs in this new witness statement that I have referred to, which is starting from page number 556, which is submitted by Mr. Chauhan. And if I may please, with your permission.
Mrs. B. Joy, is this not responded to, this statement?
No, Your Honor, this is one of the witness statement that we will be seeking the clarification. This is the 7th witness statement submitted by Mr. Chauhan.
I'm sorry. So, yes, I'm sorry. Forgive me. So many witness statements again. I was confused. Yes, you are entitled to ask about this. Yes. Where do you want to take him to?
Yeah. Mr. Ajari, if I may please take you to paragraph number 4 of Mr. Chauhan's 7th witness statement.
I can see that, yes.
If you may please take a moment to read through paragraph number 4, you can see that Mr. Shakti is contenting your earlier position in paragraph number 4, wherein he says that Wingold is not an investor, but a client. So it was a trading account. That is a position taken by you in your earlier witness statement. Secondly, he's also contenting you by saying any cost related to transactions with witness Wingold was borne by the claimant only. And the third, that the agreement with Wingold was terminated in August 2019. So I say that I will limit my responses to these 3 points. So basically, these are the 3 points which are being addressed in the 7th witness statement of Mr. Chauhan. So can you, for the benefit of the court and for us, give clarity on what was the transaction that is under reference in this paragraph number 4, which I believe has reference to the gold client agreement found on bundle page reference number 243.
Understood.
Is
In fact,
that the 243?
Yes, Your Honor.
You want me to look at that, do you?
Yes, 243. If you may want to please have a look at page number 243. And I see that this is a structuring done by you on behalf of Snyder, and you are a signatory to this agreement.
Yes.
So can you give us a background about this, the nature of the transaction, and specifically address the points raised by Mr. Chauhan in paragraph number 4 of his 7th witness statement?
Got it. Perfect. I understood completely. So, Your Honor, can I take you to page number 243 of the bundle?
I'm looking at it.
Okay, let me also bring that up. So, you know, this was the structure or the agreement that we did with Wingold and not only me, but Dino is a signatory as well. I just want to highlight 3 things, because Shakti keeps saying that it's an investor agreement. If you see the heading itself, it says Gold Client Agreement, and this is on page number 243. And I want to just highlight 3-4 points which should inform this discussion around WinGold. So number 1, it says Gold Client Agreement. It has a specific start date of 26th Feb 2019. If you go to point number 3, it's very important because it says Shakti Chauhan, 100% shareholding, key founder, which means he's well aware of what is the content of this agreement. He's the general manager, which you can see in point number 4. And then if you go to point 8, Your Honor.
Yes.
It gives you a maturity period of this contract, which is 6 months. It's not 5 years, Your Honor. It has a rate attached to it, 6%. It is not zero cost. And also on point number 9.
But who bought, Mr. Acharya, who bore the costs of the Vingold investment? Who bore the costs?
Sam Precious Metals bore the costs. Because I was involved in this transaction with them. From what I recall, it was Sam Precious Metals. In fact, point number 9 is very clear, Your Honor. If you see point number 9, it says, yes, and I repeat and I read it out, the gold will be deposited in the company's client account with Sam Precious Metals for a duration of 6 months for Sam to generate shared returns with the company based on Sam's utilization of the gold in its business. It's not investment. And it says Sam will generate shared returns. So it's very clear. And Shakti himself is the manager, owner of this company, that it was always intended to be for a period of 6 months and generate shared returns for this company. In fact,
pause there. Pause, please. Let me read this. So, putting it simply, Vingold is to get under this trading agreement 6% annualized profit after 6 months from the day the gold deposit is made. And then under 9, the discretionary mandate, the gold will be deposited in the company's client account, that is Snyder Prime's client account, with Sam Precious Metals for a duration of 6 months for Sam to generate shared returns with Snyder Prime. Is that right? The company Vingold. With Snyder Prime or with Vingold?
Vingold. And I'll take you to those points as well.
No, wait a minute. That's not right, Mr. Acharya, is it? Look at the agreement. 6% annualized profit rate is for, this is an agreement between Vingold and Snyder Global, as it is actually here, not Snyder Prime, right? And Snyder Global is the company, not Vingold, right? So when we look at returns, 6% annualized profit rate with a maturity of 6 months from day the gold deposit is made, those are the investors' returns. Those are Vingold's returns, correct?
Your Honor, small clarification.
Is that correct or not?
Yes, it's for Vingold, yes. Paid by Sam Precious Metals to Vingold, yes.
Now look at the discretionary mandate, 9. The gold will be deposited in the company's client account, that is Snyder's client account, with Sam, correct? You're nodding, is that correct?
Your Honor, the client is, if you see the first line, it says client is Vingold, the investor. And just to give you some context, Your Honor, the 6% is up to 6%. It's not a guaranteed 6%. And why I'm saying this is because Once this agreement was closed, and I've attached that as another exhibit, there are monthly returns which have been given to Wingold. Proof is on page number 243 of this bundle.
Wait, Mr. Acharya. You are confusing me enormously here. There is a lack of proper definition that you're giving in your evidence about which companies these clauses are referring to, and I need to know which companies they are. So, who is entitled to the return under item 8?
Wingold, Your Honor.
Vingold, right. Pause there. Item 9, the gold will be deposited in the company's client account with SAM Precious Metals. Listen to my question. Which company's client account with SAM Precious Metals will the gold be deposited with?
Snyder Global DMCC.
Sorry, didn't hear you.
Snyder Global DMCC, Your Honor.
That's what I thought. And it's there for 6 months for SAM to generate shared returns with the company. Which company?
Snyder Global, Your Honor.
Based on SAM's utilization of the gold in its business. So, am I right then that Snyder agrees to pay a 6% annualized profit rate to Vingold with a maturity of 6 months from the shared returns that SAM generates with the gold?
Yes, Your
Correct?
Honor.
Right.
That's correct.
Now, you may move on to elaborate your answer by reference to the other document you wanted to draw my attention to.
Sure, Your Honor. Just to elaborate on this, the 6% was a upward or a target return. And if I could draw your attention to page number 234. If you are on page 34, Your Honor, this is an email that was sent to Wingold, represented by Mehul, which showed exactly how much. Sorry. So if you can see this email, Your Honor, it says it gives you exactly how much returns were generated, which were then given to Wingold. Now, what is important is that the returns vary for May, June, and July. Specifically, it's 0.65% for May, it's 0.75% for June, and 0.85% for July. It's a clear trading account because the variability in this is precisely because the trading returns are of a variable nature.
Clearly trading account because the returns are a variable in nature, correct?
Yes. Yes. And to elaborate further, Your Honor, this was cancelled.
You mean the agreement we were looking at page 243? You're telling me that was cancelled,
If you go to, yes, if you go, and after the 6-month period was over, if you go to page 235,
yes,
it's a cancellation agreement, a cancellation, which says, with reference to your agreement dated 26th Feb between Snyder Global and Wingold, the agreement expired on 26th August 2019, which is 6 months. And as per our mutual understanding, the parties do not wish to extend this agreement further. And the last paragraph will clarify what you asked me. As per Wingold's instructions to Snyder Global DMCC, please pay all inclusive accrued returns to Wingold. So SAM gave returns to Snyder Global, and Snyder Global gave the returns to Wingold. So
Pause a
there
moment.
was a
Pause. So just explain to me the last paragraph. I accept what you're saying, that the agreement between Snyder and Vingold is shown to be terminated by this. But what does this mean? Also transfer Vingold's investment from Snyder Global DMCC's account with Sam Precious Metals to Vingold's account with Sam Precious Metals. What was Vingold's account with Sam Precious Metals?
So, Your Honor, Vingold had multiple relationships with Sam Precious Metals. To the best of my knowledge, if you see not just Vingold, even Snyder Global DMCC, every entity has either an investment relationship or a trading relationship with Sam Precious Metals.
So this
at
is
the end of the day,
this is Vingold's own trading relationship with Sam.
yes.
But wait a moment,
Yes,
let me
because at the end of the day, yeah.
Right, I have that point, thank you. You were saying at the end of the day?
At the end of the day, Your Honor, Sam Precious Metals is a refinery with a lot of trading counterparts. It's not an investment company or any such company.
Very well.
It has multiple relationships with counterparties in the world. And this is where the defendant has been trying to muddle everything together.
Say that again, the defendant has been trying to what?
I'm saying the defendant is trying to muddle, like mix a lot of concepts together. Sam Precious Metals had two distinct relationships in this whole structure that we are discussing: trading and investment. If you want to understand very clearly, any returns that are variable, varying monthly to monthly, with references to word like generate, shared returns, those are clear words that define trading.
Very well.
If you want to, yeah.
Yes, thank you. I have that point. Yes, I think we can move on from that. Can we, Mrs. Bejoy?
Yes, Your Honor.
Judge, I just want to make one more point in this because it came up in the last hearing. I also want you to draw attention to page 218, and then I will end this chapter.
218?
Page 218. Yes.
Um,
And I'll tell you why this is important.
yes.
You wanting to, this comes from your question in chief, which I permitted for him to respond to.
No, Your Honor, definitely I will have a question on that. But before he moves on the topic that we were previously discussing, I wanted him to show or refer to one more document and give an explanation, if I may please, with your permission, permitted to.
Is it, I'm looking at page 218 now.
I would like Mr. Acharya to refer to page number 217, because that will then clarify the discussion point that we were previously talking. Then he can move on to 218. So if,
can you
with your kind permission, Your Honor, if I may please take Mr. Acharya to page number 217 and explain to the court how the 6%.
Just a moment. Unfortunately, my bundle has gone awry.
Yes, this will be in a slanted position, Your Honor. I can understand. In bundle, it's appearing.
Wait, please wait a moment. Please wait a moment whilst this resolves itself. What is the page number again?
217, Your Honor.
Right, I have it in proper view now.
Yes, so the question that I want Mr. Acharya to clarify is the entry recorded as 27th of August 2019 for a credit of US dollars 113,554.66 to the Win Gold account of Sam Precious. Can you please give us a little bit of background on what this credit is and why it is credited to the Win Gold account of Sam Precious?
This is what Sam could generate from the money given by Wingold to Sam Precious Metals through Snyder Global's account. And
Just
this is
pause.
clearly a cost to Sam Precious Metals.
Perhaps you can go a little slower, Mr. Acharya, so that the court can make note, please.
Sorry,
Thank you.
So
please wait a minute. You are familiar with these documents. I received them this morning. This morning. I have not had an opportunity to read them, consider them. There are 598 pages by reason of these late filings of documents. I need to pause to read them before you start giving evidence about them. So please show a little respect in that regard. So you've introduced the document, you've not told me what it is. So I am trying to ascertain that. It is a statement of account generated by Sam Precious Metals in respect of its Vingold hedging account, right? That's
Yes.
correct. That's correct. And it shows transactions which include debits and credits. And you are relying on a credit entry of the 27th of August. There's a document number which describes the credit as interest of the amount there stated, 113,000, transferred from the account of Snyder Global DMCC to Vingold. And you're telling me that that is a cost to Sam.
Yes,
Correct?
Yes.
So then explain to me, why does it say that it is a credit transferred or interest transferred from the account of Snyder Global to Vingold?
Okay. So, Your Honor, two things on this. One is, if you note the date is 27th August 2019.
Yes.
Which is one day after the expiry of the gold client agreement, which was, if you remember, expiring on 26th August 2019.
I do remember.
When that relationship ended, whatever returns Sam had accrued, because Vingold had given money to Snyder Global's account with Sam Precious Metals.
I see.
So Sam Precious Metals paid the interest into Snyder Global to Vingold. So if you understand, it is written in that manner because money came from Vingold to Snyder Global to Sam Precious Metals. This language had to be written in a manner where Sam is ultimately paying it to Vingold one day after the expiry of the contract.
So this shows that Sam paid the interest costs due to Vingold under the gold investment agreement with Snyder, correct?
One correction, gold client agreement, Your Honor, not gold investment agreement.
Sorry, gold what?
Gold client agreement, not gold
Gold.
investment agreement.
Sorry, gold client agreement. Yes, that's what it's entitled. I'm sorry. That was my mistake. Right. So now...
And just one last point, Asha, if you allow me to take to page 218.
Mr. Acharya, I would also like you to please refer to page number 212 and also give an explanation for what these entries are, which is again a statement of account drawn on the letterhead of Sam Precious Metals, which shows interest calculations from 1st March 2019 till 26th August 2019. It's on page number 212 of the new supplemental bundle.
Yes, it is the same thing. It's what interest is being accrued and calculated and getting added to be paid to Win Gold once the facility matures after 6 months.
And do you also...
Sorry, this shows interest being accrued.
Accrued to be paid
Yeah.
to Win Gold. It adds more credence to the same point, Your Honor, that it is trading account generating returns, cost borne by Sam Precious Metals.
And you also...
definitely,
Mr. Acharya, I've got that point. Mrs. Bijoy, you are being very unhelpful in the way that you're firing references to these documents without explaining what they are, without drawing my attention to the heading on them, so that I'm being confused by the manner in which you are presenting this evidence. It is most unsatisfactory and unacceptable, and not in accordance with proper technique of examination in chief. Do I have to teach you how to do it? To say, will you please, Mr. Acharya, look at the document at page whatever it is. What is this document? What does it show? This will not do.
So grateful please, for the guidance, Your Honor. Apologize for the inconvenience. I will be mindful going forward.
Please moderate your approach in that manner accordingly. And we'll deal with matters a lot more swiftly. And apart from the fact that I'm looking at it with my head askew, because if I do the rotate button, it will take an age to go through. So the point is that this shows interest being accrued, which is typical of it being a trading account and not an investment account.
And it's daily, Your Honor. If you see the ledger, it's a daily calculation.
Daily calculation.
I have never seen a working capital which does daily calculations. It's clearly a gold trading account. In fact, the heading of the document says interest calculations as well.
I've just spotted that myself, but that wasn't drawn to my attention when the document was introduced. That's what I'm complaining about and must not happen again. Right. Now, you wanted to refer me to page 214 for some purpose.
218, Your Honor. And it's very important.
218.
218. Yes. And I'll tell you why, Your Honor, if you remember.
Wait a moment, please. Now, I'm going to have to rotate all of these documents again. Right. Well, you heard me say to Mrs. Bejoy what I require. What is this document?
Understood, Your Honor. So, Your Honor, if you remember, when Shakti's hearing transpired last time, he made a specific mention why Windgold transaction was structured through Snyder Global to go to Sam Precious Metals. And if you remember, he said because Mehul, the owner of Windgold, has a negative world check. And you specifically asked him, what is world check? I just want to pinpoint that he lied blatantly to the court. This is the world check report. Mehul has no negative thing on world check. And I was confused because I have apps. That was not the reason this Windgold agreement was made. I got confused. I thought I was mistaken. And I felt that this document should be up there because he very casually introduced he derailed the whole hearing, stating that there is a negative world check on Windgold and Mehul. And there it is not there. And this is what because I was involved in the transaction, I had to go back into my records because we take all these things very seriously. This is just what I wanted to point out, Your Honor.
Well, I'm grateful to you for that. Thank you very much. So the key record here, am I right, is no matches found?
Yes,
Key
Your Honor.
findings, no matches found?
Yes, Your Honor.
Very well. So, Mrs. Bejoy, please ask your next question on whatever your next topic is.
Yes, Your Honor. Thank you. Mr. Acharya, I would like to again refer you back to the 7th witness statement of Mr. Chauhan.
Which page is that?
Starting on page number 556 of the supplementary bundle.
Yes.
Can you tell me from the section, Asha?
Yeah, it is section I and paragraph number 4.
Okay. Statement number 7. Okay, understood.
Yes.
Got it.
And in paragraph number 4, Mr. Chauhan takes a position that the Windgold agreement was renewed post-August 2019. I would like you to clarify the correctness of that position.
That's good. So, Your Honor, as far as I know, it was not renewed in the name of Snyder Prime Limited or Snyder Global DMCC. There is no such document signed between Windgold and Snyder Global DMCC or Snyder Prime Limited that I am aware of that shows that it was renewed on account of Snyder Global DMCC or Snyder Prime. And I just want to add one more point. There's a reason I was not able to address witness statement number 7 because it is so confusing and all over the place. Because in point 4, Shakti Chauhan states that he will address Windgold. But if you read the witness statement, he casually skirts around Windgold and introduces 5 new parties in the mix. He introduces somebody called Tijan, introduces Alepi, Imperial, P79 structured trade, and I had absolutely no idea how to respond to this. My only complaint to Asha was that, I was recalled as a witness specifically for Windgold, and we have addressed that in a lot of depth. I took out time to address that. Now it is unfair for me to make sense of rambling statements. I have no idea what is Tijan, P79 structured trade. It is limitless, Your Honor. And
well, I've already noted the stark irrelevance of a lot of this evidence, and I understand the difficulty that you face with it. I will hear Mr. Ghosh if he seeks to justify this evidence, the inclusion of this evidence in terms of its content. I've already made certain rulings in relation to the propriety of introducing it, and I will deal with it appropriately in my judgment in due course. So I don't require, indeed it's irrelevant and therefore it's not admissible, any evidence about these other matters. Mrs. Bejoy, move on, please.
Your Honor, that's from my side at the moment, Your Honor. I do not have any further clarification to Mr. Acharya. Thank you very much.
Thank you very much. Mr. Acharya, you're now going to be cross-examined by Mr. Ghosh, who will be putting to you what is relevant to the issues that I have to decide in this case. Yes, Mr. Ghosh.
Yes, Your Honor. So, Mr. Acharya, coming back to page 233 and 238, which you referred to.
Okay, 233.
Yeah, I'll tell you the section number, 1 second. Section number, this is
I found it. I found it.
Yeah.
I found it, yes. 233, right? It's a WhatsApp chat.
Correct. This is one of the your exhibits, actually.
Yes.
Yeah. In this particular WhatsApp chat, Shakti, there is, it's named as Shakti Java Dubai Main.
Yes.
Where I am assuming it's Shakti only. Separately, I had an earlier chat of moving Mehul from Snyder Global SCMM to Imperial General Trading LLC.
Wait a minute, Mr. Ghosh.
Yes, Your Honor.
Please introduce the document properly, as I've just been telling Mrs. Bejoy. Who is involved in this WhatsApp chat? Who are the parties to it? Where does it start? Where should I start reading?
Yes, Your Honor. It starts at page 233. It's a conversation.
233.
Yes.
So, Dino is Mr. Skandalis, I presume.
Yes.
And Dhruva is Mr. Acharya. Is this a chat just between the two of them then?
No, Mr. Shakti is also there.
So where do I see that Mr. Shakti is there at the head at the where it starts at the heading, page 233?
I mean, this is not showing, his name is not there on the top. And this is an exhibit which Mr. Acharya has produced. But if we go down below, we find the name of Mr. Shakti. On the same page, a little down, Shakti Jabba Dubai Main.
Okay, so that is Mr. Shakti. What does Jabba Dubai Main mean?
I think it's a new number which he has saved in that manner.
All right, very well. So Mr. Shakti is in this conversation now. So it's a conversation between Dino, Dhruva, and Shakti.
Yes, Your Honor.
Go on, take me to what you want me to look at.
So, Mr. Shakti, this Shakti Jabba Dubai Main, it's written separately. I had an earlier chat of moving Mehul from Snyder Global SCMM to Imperial General Trading LLC. So, what is this? I mean, practically, I wanted to understand from you, Mr. Dhruva, what is the context of moving Mehul, which is Wingold, from Snyder Global SCMM to Imperial General Trading LLC?
Okay. Should I start?
Yes, please.
And answer the question. What's going on here?
Your Honor, I have absolutely no idea, and I'll tell you why. We had 20 WhatsApp groups between all of us. We had continuous discussions, and Shantanu is a lawyer. Shantanu, is there an agreement between Snyder Global and Imperial that you have submitted with
Mr.
context
Acharya,
and
don't ask
background.
me questions. Please answer.
Well, can you ask him a question
What is the
clearly?
question? You can't just say a
Or,
line and say, what does this mean? You tell me what it
Mr.
means and I can
Acharya,
clarify.
Mr. Acharya, be quiet. Be quiet. Mr. Ghosh, will you please either ask a question about these words or put a case, a suggestion as to what they are about so the witness can deal with it?
Yes.
What
Yes,
is your question or your suggestion to the witness?
So I'll put a suggestion, Mr. Acharya. This conversation by Mr. Shakti, where he mentions separately, I had an earlier chat of moving Mehul from Snyder Global SCMM to Imperial General Trading LLC, is actually a continuation of Wingold investment with the claimant number 1 after the termination of the agreement between Snyder Global, DMCC and Wingold.
What do you say to that?
Let me address that. Number one, I think I've amply clarified that the agreement between Snyder Global, DMCC, and Wingold was a trading agreement. That I think I've spent enough time clarifying that. So you cannot now relabel that as an investment and connect it with this. Point number two, I have no idea what is Imperial Global General Trading. I have no idea whether this was done or not done. And it could be a trading. So Imperial name, if I can read the name, it says General Trading LLC. Maybe starting a new
So you
trading
disagree?
associate.
So you disagree with my suggestion? That's it, right?
Santanu, suggestion is meaningless. I can suggest one thing, that there are other chat groups where Shakti negated this point. Suggestion is meaningless, Shantanu. In fact, I would also like to state on this.
I have your answer. You've put your suggestion, Mr. Ghosh. Move on to something else.
Yes. Going down a bit below, in the same page, here Mr. Shakti says, when we say investments, let's ensure Snyder and P79 are also protected. And let Sammy know that we are not licensed to take investment other than the fund should move Mehul to come and invest over there. So my suggestion here is, because Snyder Global DMCC did not have the license to take investment other than the fund is P79. That is why the agreement which you are referring to between Wingold and Snyder Global DMCC has been nomenclatured as client agreement, not investment agreement. Do you agree?
That's a logical fallacy. That's a logical fallacy. Absolutely not. At that point in time, Shakti was also simultaneously trying to convince Mehul to invest in a fund that he set up in DIFC. And like I said, Your Honor, it is absolutely irrelevant to this conversation. Why are we discussing a DIFC fund when we have to discuss specifically Wingold? Shakti was attempting to make Mehul invest into that fund, and he was unsuccessful in that venture. You are creating a clear logical fallacy by negating my statement with a logical fallacy. It was never an investment agreement, Shantanu. Investments do not have variable returns every month.
Yes,
And
I've got
you
that.
as a lawyer,
Mr. Acharya, I've got that point, and you've dealt with the suggestion fully that's been put to you. Thank you. Mr. Ghosh, move on.
Yes, I'll just.
I have a small question which I also need to clarify.
Well, wait a minute,
This is a
Mr.
chat.
Acharya. You are not there to ask questions. If you wish to elaborate upon an answer or clarify an answer, you may do so, but do not ask questions.
Understood. Got it.
So regarding the costs, which you mentioned that the claimant number 1 had borne the entire costs of all the investments. If you come to page 187,
187. Okay.
I'll tell you the.
Yep.
187 is section D.
Yep.
And what is this?
I'll inform. I'll just mention the document, Your Honor. This is an email which was sent from Mr. Mohammed Fakran, 7th of April 2019, to Shakti Chauhan, stating about the 10% JV consultancy fees, which according to the MOU, he was entitled to. So where if we go down below, he writes, "Dear Shakti, good day. I'm attaching in this email the allocation of the profit and bonus till March 31st, 2019. As per your conversation with Sammy, we have allocated 30% to the directors and employees and 70% to be shared between shareholders. Please share approval on the same. Please also note that we will not allocate 10% profit for this period as agreement between partners due to other costs generated from the delay in providing the gold for the JV." So from the email, it's very clear that 10% cost will not be allocated to Mr. Shakti Chauhan due to other costs generated from the delay in providing the gold for the JV. So do you have any idea, or do you know what are the other costs which he is referring to?
Shantanu, do you have a question for me? You can't read a line and just say the comment on this. I have no idea what you're trying to say in this
Mr.
line.
Acharya, he's asked you a question. What are the other costs? Do you know what the other costs that this writer, Mr. Fakran, is referring to in the sentence that's been read to you? You've not.
So,
What he's saying, we will not allocate 10% profit for this period, presumably to you, Mr. Shakti, as agreement between partners. That's referring to the MOU, due to other costs generated. Mr. Ghosh is asking you, do you know what those other costs are? That is the only question you're being asked.
I don't, Your Honor, because I'm not a part of this mail chain. But if I had to hazard a guess, if Sam had capital shortfall, it might have had to raise money from other third parties to fulfill the shortfall. But I'm not sure because I'm not a part of this mail chain, Your Honor.
Right. That's as far
I can't recall.
That's as far as you can go. That's as you said, a guess.
Yeah. Thank you.
Very well.
Yeah.
Mr. Ghosh, do you have anything else to ask about this email?
Yes. No, on the continuation of that email, kindly come to the next page, page 188.
Second, 188.
This is a statement of account produced by Mr. Shakti Chauhan, his own statement of account from Emirates NBD. And we go down the second page of the statement of account, which is 189. The period for this account is 4th February 2018 to 8th July 2021. So are you there, Mr. Acharya? Page 189.
I am there, yes. What is your point?
So here, there are two dates, 14th January 2020 and again 14th January 2020, where Mr. Shakti Chauhan claims that these are the amounts which has been paid to him after deduction of the costs due to the gold invested through Snyder Prime Limited. My suggestion to you is, it's not a question, it's a suggestion, that the costs which you mentioned has been borne by the claimant has ultimately been deducted from Mr. Shakti Chauhan's JV company.
No, you're misleading everything. You're misleading everyone, Shantanu. Once again, you're confusing multiple concepts. One, there is a cost Sam has to incur in its operations. There is a JV fee due to Shakti. The JV fee is clearly based on the capital contribution brought in by Shakti Chauhan. And I will take you, if you want clarity on this, page page number 581 should clarify this misdirection very clearly, Your Honor. Is everybody on page number 581?
Yes, what is this? Remembering that you're answering the question, sorry, the suggestion that's put to you, which is that the costs that you say were borne by Sam were in fact borne by Mr. Shakti. That's what's being put to you, and you're using this document to reject that suggestion, as I understand it. Is that right?
Yes, what I'm doing, Your Honor, is I'm giving context behind JV fee calculation because Shantanu keeps adding costs. I'm making a point that the JV fee was clearly linked to the capital contribution versus committed capital contribution of Snyder Prime Limited or Shakti Chauhan. In fact, it was prorated. For example, and I'm sorry, I'm not a lawyer. I'll give you some context on this director's meeting.
Just refer to this. You want to refer to this document,
Yes.
581. I'm looking at it. What is it? What do you want to tell me? Point out to me that's in it.
Sure. So if you go to point number 1, just below whereas, right? Point number 1. It says to JV company consultant, that is Shakti Chauhan, for 2018, basis the agreement which says 10% net profit, $1522 adjusting for actual convertible loan capital contributed versus target. So the target is the 200 kgs, Your Honor. The reason it becomes from 8 million in point number 1 to 9 million in point number 2, which is the target, is because the gold price has gone up. So all I'm trying to say is the JV fee computation was based on 10% prorated against what he actually brought in versus what he committed. Not this other costs. And Shantu is trying to confuse all matters through WhatsApp chats. And I'm trying to show you agreements and board resolutions and board meetings.
So he got less because he had not introduced the investment capital that he had promised.
Yes.
And
in
he
fact,
got
this
less.
is very yes.
He got less in amounts that were calculated by a proration of the difference between what he had promised to bring in as invested capital and what he actually brought in. And this document, an important document, demonstrates that and answers Mr. Ghosh's suggestion to you that he was bearing the costs of trading deposits. That's not correct, is it? I understand what you're saying by reference to this. Mr. Ghosh, do you want to come back on that and demonstrate that what the witness has said is incorrect in any respect?
Then again, we have to go back to the old documents, which Lordship, I will prefer putting it in the closing submissions.
Very well. You can deal with it in your closing submissions. You can see if you can persuade me to the contrary of my understanding of this evidence that has just been given in answer to your suggestion by Mr. Acharya.
Yes, Your Honor.
Mrs. B. Joy. I'm sorry, Mr. Ghosh.
Yes. So this cross-examination is related to Mr. Acharya's second witness statement, I believe, right? I'm getting confused again. Actually, there are 3 witness statements by Mr. Acharya. So,
well, ask your question, please.
Yes. So, please come to page 561.
1 second. 61. Okay.
1 second.
Now remember, I want to know what this is, who it's between.
Yes, Your Honor. I'll just.
And what is it? It's an exhibit produced.
No, I'll come to page 577, which is the third witness statement of Mr. Acharya.
577, okay.
577, right.
So here, you have mentioned about in paragraph 7, this is the third witness statement. In paragraph 7, you're mentioning about the 3 promissory notes. So I'll go to 7C. I'll just limit my question to Al Shahid Jewelry. Exhibit SC20 is a promissory note in favor of Al Shahid Jewelry issued by claimant number 1 for a period of 1 year. I believe, based on submissions and representations made by the claimant, that this facility was repaid on 5th January 2019, much before the promissory note maturity date of 30th December 2019. This again demonstrates that the promissory note was of the nature of a post-dated check made for accounting purposes. Now, Mr. Acharya, it has been the stand of the claimant, all the witnesses practically, that when the amount came from Al Shahir Jewelry at the end of December 2018, it was returned back within 5 or 6 days. So what was the benefit of getting that money? Why was it necessary to issue a promissory note at the end of the day? Are you aware of it?
So I'm not a party to this conversation, Your Honor. I only commented on this because Shakti put these evidences in response to me. But I would like to, what I've written here, Shantanu, is a simple fact that these are 1-year promissory notes, again, not 5 years. And I made one more point, Your Honor, which is more important, is that he is trying to show promissory notes as shareholder resolutions or board resolutions. That's all the observation that I made in this. I am not a part of Al Shahir. I don't know why this transaction was done. All I'm saying is this is irrelevant. It's not a 5-year working capital facility, as far as I'm concerned. And he has casually written in response to my witness statement that these are board resolutions, which they are clearly not. They are promissory notes.
Well, I've already ruled that they are not board resolutions in a judgment relating to these documents. Plainly, they're misrepresented as board resolutions. But I would like to know if you can help us. You may not be able to help us. If the amount of money that we're talking about here was taken from Al Shahir at the end of 2018 and repaid a week later, can you give any explanation why there would be a promissory note, even only for 1 year, if it was such a short-term transaction?
Understood, Your Honor. So, Your Honor, I will give you an answer, which is a statement because I've been working with everyone for a long period of time. This concept called promissory note was introduced to our broader group by a gentleman named Dinos Candales, who's also a witness, by the way. You can ask him this question as well. So Shakti had gotten into a habit of creating promissory notes like he was printing out, paper. And what we decided as a group is that in case there is an outstanding balance or in case there is some give and take of money, sometimes it is quick to write a promissory note. That is the only reason, because otherwise you will have to write a big agreement. Let's say somebody is giving you money for 5 days or 6 days. Rather than spending time to write a 20-30 page agreement, sometimes it could have been convenient to write a promissory note. That is my subjective answer. I don't know. I did not sign this agreement or write this agreement.
Very
but
well.
That is what I would offer as an explanation. Because sometimes, Your Honor, when you are doing accounts and there are outstanding balances, you have to have supporting paperwork. So it is purely for paperwork purposes. In fact, because there are so many transactions, there are give and take and transaction set off. If at the end of the year, your accounting head comes to the CFO and say, look, there is a receivable of 500,000 dirhams. How do you want to put this receivable? So sometimes it is easy to create a promissory note to build a paperwork around that outstanding balance. That is it. You can't read too much into a promissory note without having the accompanying agreement or side letter.
Very well. Thank you for that assistance. Mr. Ghosh, do you want to move on?
No further questions, Your Honor.
Right. Thank you very much. Do you have any re-examination, Mrs. B. Joy?
No, I don't have any, Your Honor. Thank you.
Right. Mr. Acharya, thank you once again for your assistance. Your evidence is now complete and you are released. as a witness.
Thank you, Your Honor. Have a good day, everyone. Thank you.
Thank you. So now, Mr. Skandalis. Who is just to be cross-examined
Yes. Yeah.
and re-examined, if you see fit, Ms. Bijoy.
May I have a glass of water, Your Honor?
Yes, certainly. Well, it's coming up there 1 o'clock, isn't it? What time? I'm just thinking. How long do you think you'll be with Mr. Skandalis, Mr. Ghosh? If we finish Mr. Skandalis, then we've just got Mr. Garg. You said you had 1 or 2 questions for him. There's Mr. Skandalis now with us.
Probably there are 10 to 15 questions. That's
right. And very well. Well, I don't want to keep everybody from their lunch. Would it be convenient if I adjourn? Hopefully we'll finish Mr. Skandalis in half an hour from now. Does that cause, is that satisfactory for everybody? And we'll take an hour's break for lunch at 1:30 in Dubai. Very well. Thank you. So, Mr. Skandalis, thank you for returning to be further cross-examined and possibly re-examined. You are still subject to the affirmation of truth you gave about your evidence. That remains binding upon you. And you will now be asked some questions by Mr. Ghosh.
Thank you, Your Honor. Good afternoon to everyone.
Good afternoon.
good afternoon. So, Mrs. Skandalis said, please come to page 240.
Of the supplementary bundle.
Yes, of the supplementary bundle.
Yeah.
It is.
Yes, I'm there, Mr. Ghosh.
It's your second witness statement, yes. So here, you have mentioned in paragraph 3 that Mr. Shakti Chauhan, in the middle of paragraph 3, where exhibit SC11 is also mentioned by you, Mr. Shakti Chauhan attempts to confuse the code by conflating the year-end 2018 transaction involving 49.750 kg of gold from Al Shahir, which was returned on 5th January, and with the 6th month Wingold transaction that commenced on 1st March 2019 and terminated on 26th August 2019. So from where did you get this, imagination of conflation when it is very clear from all the documents that both are clearly different?
That's the impression that I got. Can we revisit exhibit SC11? If you can direct me where that is.
Yes, let me check.
Please.
SC11 will be at page
149.
Yeah, 149.
Thank you.
Okay, just give me a second.
Sorry, what did you say again? 149?
149 of the supplement bundle.
It's a group between the directors of the claimant number 1, I believe Mr. Sami is there, and Mr. Dhruva is there.
Your Honor, I believe, Mr. Ghosh, I believe in that group would be Mr. Sami, Mr. Shakti, Mr. Dhruva, and myself. At least, the 4 of us. Golf Group Sami. Okay?
Yes.
So what I made reference to that, I believe, let me check, is the second page of that WhatsApp. And towards the bottom of the second page, there are some annotations in the yellow space, I believe provided by the defendants. And it says 1 1st March 18 to August 18, 6 months already. So that would relate to the Vingold client agreement that I was asked to put together with Mr. Acharya. Number 2 states convertible loan was booked in the 2018 AFS at the end of the year, i.e. December 2018. And then it says 1st March 18, December 18, 9 months. So what the convertible loan that was booked in 2018 AFS at the end of the year, I'm not sure. That's where I don't know where he's getting the 9 months. The 6 months I know, I don't know where he's getting the 9 months and which convertible loan he is confusing with. And based on the original hearing or when the trial started, I recall that there was some reference, I think on a page 20 of a supplement to the annual financial statements of 2018 that you had brought my attention to, whereby there was, I think the ALSHA here was showing on the conversion as a convertible loan, but not on the balance sheet. So that's where my confusion was, and that's the reference.
Okay. Okay. So again, going back to page 240, which is your second witness statement.
Mm-hmm.
At the end of paragraph 3, you mentioned that I submit that what was arranged provided by defendant number 1 regarding the 200 kg gold was as follows. That 4.9 currency loan from Al Asil and 1.04 loan from Snyder Prime Limited.
Yes.
So do you admit that these two form, I mean, my assumption is you clearly admit, but still I'm asking you a question. Do you admit that these fall within the criteria of 200 kg gold?
Well, these two were contributed, and I mentioned during my previous examination that those two also appear in the financial statements, audited financial statements, which I also signed 2018 to 2019. And they also appear in the STA, which was executed on the 5th of February 2020. The 4.9 million was to be replaced and was replaced by the 100 kg gold from Rosesan, and the 1,041,711, which came from Snyder Prime itself. I'm not sure if it was paid in by Snyder Prime or one of their associates, but it came from Snyder Prime. 291 were paid back to Snyder Prime, and 750 was set off against an entity called Kochi. That's in the STA 4.2, right? So these were contributions, both this amount contributions made by, in dollar terms, arranged or made by Snyder Prime Limited. Now, in terms of how the shareholders treated the 1,041,711 in terms of the amount that was paid back, if that formed an actual part of the 200 kg or not, that was between the shareholders. But as far as myself was concerned, these were the amounts that were contributed.
Yes, but Mr. Skandalis, to be clear, I think what Mr. Ghosh is trying to do is to play on the fact, the sentence, this assertion has no basis whatsoever. And this sentence is what he's drawing your attention to. I submit that what was arranged provided by defendant number 1 regarding the 200 kilograms of gold was as follows. Can I be clear? Yes. You're not suggesting that this amounted to the provision of 200 kilograms of gold.
No.
It is the 4.9 is to do with an alternative provision of US dollars in lieu of 100 kilograms of gold. That's correct, is it not?
Correct, Your Honor. I don't deal in kgs. I deal in dollars.
Exactly. So the sentence there, I submit that what was arranged provided by defendant number 1 regarding the 200 kilograms of gold. I want to be clear, you're not suggesting that these contributions amounted to the provision of the equivalent of 200 kilograms of gold?
No, it would have been part of, not 200 kg.
Exactly.
I mean, obviously, you can do the relevant conversions based on the gold price at whatever time, and you arrive at exactly what it is.
Very well. Mr. Ghosh, that was, I'm sorry to say it, that was really a misleading question. And I had to intervene in order to make sure that the import of this evidence is properly understood. This is not the witness stating that 200 kilograms of gold was provided.
No, Your Honor, that was actually not the intention. I understand that what you meant, but he said regarding the 200 kg gold, which means that these two form part of the 200 kg gold. It's not complete 200 kg gold. I appreciate that, Your Honor, but
Very well.
that's
As
not my...
as long as that's clear.
Yes. So, Mr. Skandalis, can I suggest, based on this last question which I asked you, that the only point of dispute regarding the 200 kg gold, if at all there is a dispute and if at all there is an obligation, which we dispute, by the way, is the Al-Shahir one. If Al-Shahir is considered as a part of 200 kg gold, then the cycle is complete, 4.91041 and Al-Shahir 2.05. It's a suggestion, Mr. Skandalis.
My answer to your suggestion...
Wait a minute. Mr. Ghosh, I cannot make head nor tail of that suggestion. First of all, specify what deposit you're referring to. You said Al-Shari, you didn't even pronounce it correctly. Which deposit are you referring to? Which amount of money?
I'll just confirm that.
Are you talking about Al-Shahir or what?
Talking about Al-Shahir. So I'm trying to find out where the amount is written.
I think there's a section C with Al-Shahir documents in the bundle.
Yeah, Al-Shahir documents, right.
Mr. Ghosh, yes.
So it starts at page 90. So, Honor, the question is, this Al-Shahir, the same company which apparently had taken out or had received the money back within 5-6 days after the amount was invested with the claimant number 1 at the end of December. So I'm referring to that. So the suggestion is the dispute based on Mr. Skandalis' averment at page 3, at paragraph 3 is, that is the only point of dispute regarding the 200 kg of gold.
I'm not going to comment on first of all, as I said, Mr. Ghosh, I deal in dollars and not gold kg. Okay. So what I've said in points A and B of paragraph 3 of my statement is crystal clear. I don't see, anything else referred into it, and his Honor's comments relating to that. I don't see a question. I don't understand what you want me to say. Whether
no, it's a suggestion. It's a suggestion only. You can disagree or agree.
Mr. Ghosh, I'm going to stop you again. You put the proposition once again that the only matter in dispute about the provision of 200 kilograms of gold was the provision of the Al-Shahir deposit, I'll call it.
Yes.
That is not the limit of the dispute. You are misrepresenting what the competing cases are here to this witness, and I will not accept that. Please formulate your questions accurately and not misleadingly.
Yes, Your Honor. So I'll skip that question or suggestion, Your Honor.
Well, are you suggesting that the Al-Shahir deposit of gold at the end of 2018 was the provision of investment capital gold in a particular amount? And if you are, please put the suggestion clearly for Mr. Skandalis to deal with it.
Yes. Okay, Mr. Skandalis, you'll remember the 3 promissory notes. The email had gone from your end asking for the promissory notes. Now, one of the promissory notes is Al-Shahid. So my suggestion is the deposit which came from Al-Shahid at the end of December 2018, if it was considered as an investment by the claimant, which they are disputing because they are saying it has been returned within 5 days, if it was considered as an investment, then the quota for 200 kg of gold or equivalent amount thereto is complete. That is my suggestion.
I cannot answer you that, Mr. Ghosh, because I have to start converting amounts into gold. And even when this exercise started, by signing the MOU on that date, I believe that 200 kg at that time was roughly $8 million. Now, as time went along and contributions were made, say for the 4.9, etc., the price of gold changed. So it could have been 9 million, it could have been 10 million, etc. Today is probably about 12 million, given the price, where the price of gold. So 200 kg in dollar terms, a moving target. Okay, so what I'm saying is 4.9 million and the 1.041 were the 2 amounts that were contributed or arranged by Snyder Prime, and those 2 will amount to a certain quantity of gold. Whether it is in the expert report or in the court, based on the dates, they can calculate how much gold that is. On the top of my head, I cannot tell you. Maybe it's 100, maybe it's 90, maybe it's 120 kg.
Okay. Coming to a last paragraph in the witness statement, it's paragraph 10.
Yes.
It's at page 242.
Yes.
In the last paragraph, you're mentioning a company. I state that the defendant number 3 is attempting to claim that certain communications between Mr. Mohammed Fakran and Mr. Anshuman from INTL may have given the impression to the latter, that is, I believe INTL, that latter means, I mean, you kindly explained to me later on, that convertible loans were increased to USD 8 million in Q1 2019, which is not accurate. I state that I had only responded to the final 2 questions, reflection in Exhibit SC9 regarding the convertibility aspect of the convertible loans. Now, with respect to this, it's
yes.
At page 143, the exhibit which you are talking of. Have you found it?
Yes, Mr. Ghosh,
Yes.
I have indeed.
So your honor has it.
Yes, I have page 143. Again, what is this?
Yes.
Who is it between?
Yes, I'll explain. This is a email, WhatsApp conversation between Mr. Sami and Mr. Shakti Chauhan. And in the second, that is at page 143, which is the second part of the WhatsApp conversation, Mr. Sami says, Snyder has a convertible loan of about 1 million. There is another $5 million. Who is this from? Such convertible loans have increased to 8 million in Q1 2019. Who injected more cash? So, Mr. Skandalis, I believe you're talking about this in your witness statement. Correct?
Just a second. Yeah, I think that is something.
The question, I'll ask you the question. The question is, you have said that it is not correct, but what is it actually?
Sorry, you did not provide the context because you did not read through. This is something that, as I can see here, Mr. Sami is relating to Mr. Shakti. You said that it's a conversation between Mr. Sami and Mr. Shakti, right?
Correct.
Okay. So that's something that has been relayed by a market counterparty, INTL, which is International Assets, which is a a major counterparty in the gold market and a counterparty of Sun.
I'm sorry, where is all this coming from, Mr. Skandalis? You're referring to parties here. All I'm looking at the moment, all I've been taken to by Mr. Ghosh is page 143, and there's a big blue square bracket around a piece of it. You've obviously read it in its context, and Mr. Ghosh has not explained its context. He's not explained which passages are attributable to which party to this conversation. Where does it start? Where does it end? Mr. Ghosh, this simply will not do. So where should I start to look at this document to understand it?
It starts at page 143 only. So I'll convert the question to a suggestion to Mr. Skandalis, that in your witness statement, you have mentioned that this conversation by Mr. Sami is not correct. My suggestion is, Mr. Sami is suggesting that 8 million had already been invested in Q1 2019.
Sorry, where did I say that Mr. Sami's conversation is not correct? Where did I reference that?
I will again go back to your witness statement.
Which is what page, Mr. Ghosh?
It is at page 242, coming to the end of the paragraph 10, just before the statement of truth. I state that the defendant number 3 is attempting to claim that certain communications between Mr. Fakran and Anshuman from INTL may have given the impression to the latter. So latter means, I don't know, that convertible loans were increased to USD 8 million in Q1 2019, which is not accurate. Now, in that conversation, which I just showed to you at page 143, which you also mentioned, reflection in Exhibit SC9, it is a conversation between Mr. Sami and Mr. Shakti Chauhan, where Mr. Sami says, we have got 8 million USD in Q1 2019.
That's not what he's saying. He's referencing to a WhatsApp between Mr. Mohammed Fakran, who was a finance officer of Sun Precious Metals, and Mr. Anshuman, who was the CEO of INTL Commodities in DMCC. That's what he's doing. That's why I say if you go further down, page 143, you will see that says thanks Anshuman. It doesn't say thanks Sami. And that's why, His Lordship is getting confused because we are not providing the correct context. I'm happy to assist
so
providing the correct context if you are not able to do that.
Mr. Skandalis, I would be grateful for some assistance because I'm not getting it from Mr. Ghosh. What would you suggest I read of this WhatsApp message? It does not start at page 143. There's material above it and there's material below it. Where would you suggest I start to read? Please help me.
I will try and assist your Lordship with my recollection based also on what is stated there. Okay. INTL Commodities DMCC, also called StoneX, which is also the INTL Commodities. The INTL group I also worked for in the past, is one of my previous employers as well. Okay.
Right.
It's a major player in the market, in the gold market, and they had a relationship with Sami. Mr. Anshuman, that you will see in that message on page 143 on the first page of the message, that says thanks Anshuman, was the general manager or CEO of that entity here in Dubai.
Okay. Sorry, page 1. I'm not seeing that. Thanks, Anshuman.
Yes, it says thanks. So what is captured there is something which Mr. Sami has captured from the correspondence was between Mr. Mohammed Fakran, who was the finance officer, and Mr. Anshuman.
Right.
Because Mr. Mohammed Fakran was providing certain financial information from time to time to all the counterparties, including INTL. sometimes on a quarterly basis or a semi-annual or an annual basis.
So just help me, who has typed Snyder has a convertible loan of about 1 million?
I think that is something that came from the tweet of, if I remember correctly, from Mr. Anshuman to Mr. Mohammed Fakran. And then Mr. Mohammed Fakran must have passed to Sami and Sami copied it.
This is utterly confusing, utterly and completely meaningless and confusing. None of it makes an ounce of sense. So you're saying, Mr. Mr. Ghosh has introduced this as a WhatsApp conversation between Sami and Shakti. I don't see anything on page 143 that tells me that. And then the only person who actually signs himself on this page 143 at the top is Anshuman. Thanks, Anshuman.
Right.
So it looks like Anshuman has written, Snyder has a convertible loan of about 1 million. There's another plus or minus 5 million. Who is this from? Such convertible loans have increased to 8 million in Q1 2019. Who injected more cash? First question. Next question, what are the terms of the convertible loan as it is showing as a current liability? Has it been converted? Thanks, Anshuman.
Correct.
That's one.
And
that's
yes.
one message at 301.
That's one message. That's one message. And what I have answered in that message is the last two questions, which are not captured in the blue. So underneath where you see from INTL, underneath you will see forwarded. Hi, brother. That's my answer. So that's what I had sent to Sami. This is me.
This is you. This is you, not Mr. Sami or Mr. Shakti. This is you writing.
No, this is the hi, brother. On last two questions, the convertible debt will be converted into preferred equity during the course of the year prior to its maturity date or can be rolled over for further periods. These are my answers to Sami, because Sami asked, okay, in terms of the conversion, how does it happen? So say, if it gets converted, then it will get converted in the course of the year, if unless it is rolled, etc. So that's why you see it is forwarded. So he's forwarding my message to Sami, to Shakti in that chat, because I'm not included in that chat. That's what it's called, it forward. But that only deals with the last two questions that Mr. Anshuman is directed to Mr. Fakran that got into Mr. Sami. I mean, so, I don't even understand what the relevance is, but anyway, I mean, that's my...
Well, neither do I, and Mr. Ghosh hasn't explained the relevance at all. This is just utter confusion. Whether it's designed to confuse me, I do not know, but it certainly is not elucidating the issue of whether there was an investment of 200 kilograms of gold, Mr. Ghosh. Do you wish to try and ask your question in a more comprehensible manner or not?
Yes, Your Honor, it's a suggestion. Basically, the claimant's the defendant's stand is, in terms of the message, it is also clear that already in the first quarter of 2019, 8 million worth of gold, equivalent to gold, was already invested through Snyder Prime Limited. That's the suggestion, Mr. Skandalis.
I don't see any confirmation of that fact by anybody associated with some precious metals.
Thank you. That's your answer. I have your answer. Thank you. Mr. Ghosh, will you move on, please?
Yes. Regarding the 3 promissory notes, what was the intention of sending the 3rd promissory note relating to Al-Shahir when Al-Shahir amount was already returned within 5 working days?
I believe it was a request again from Mr. Mohammed Fakran, but you will note that the annual audit periods cover January to 31st of December. So the first audit period for some precious metals was from, its incorporation on the 12th of March of 2018 up until 31st of December 2018. On the date of the 31st of December 2018, an amount of Al-Shahir gold had been deposited in some precious metals. That had to be captured in the audit, and for, I believe, the audit purposes, had to be evidenced by, or was a request to be evidenced by an IOU, an instrument which can take many forms, but the easiest and most usable instrument is a debenture in the form of a promissory note with a relevant side letter. So,
whose idea was it? Whose idea was it? Did you say it was somebody's idea?
It was, I believe it was a request for the audit process from the finance team. So the auditors,
the finance team of some precious metals?
Some precious metals, Mr. Fakran, Mr. Mohammed Fakran was the finance officer. Right. So part of the finance team coordinates the audit with the auditors. So, and the auditors will reconcile the various entries, and we will do the checks relating to, any outstanding obligations between the parties, how these are evidenced, etc. This specific obligation, together with the other two obligations, the 4.9 million and the 1.041, were evidenced by promissory note. Now, a promissory note is an IOU with a date in the future for repayment. It can be repaid on that date, or can be repaid earlier. The same, if I give you a post-dated check, then I can pay it to you earlier and get my check back. So,
like a post-dated check, you say?
Yes. So basically, that, if I remember correctly, I think we touched on this previously, Your Honor. I think initially there was some consideration as to whether this Al-Shahir will stay or not.
Would be a long-term investment.
A long-term investment. Yes,
you've given me this evidence before.
Yes.
You do not need to go there again.
Thank you, Your Honor.
So there you have your answer, Mr. Ghosh.
Yes.
These documents these promissory notes were created in respect of all three of these amounts for accounting and auditing purposes.
And also, Your Honor, if I may add, you will note, if you see on the date of the issuance of the promissory note, for example, for the 1.041 million for Snyder Prime.
Yes.
I believe that was in July, if I'm not mistaken, of 2018, maturing in, was it June or July 2019?
Well, do you want to refer me to the promissory notes, Mr. Ghosh, or?
No, I mean, are you referring to the three promissory notes? It's starts at page 491.
491?
Yes.
Just whilst we're doing this, I do not have an index to this supplementary bundle. Have you prepared an index? Mrs. Ghosh? Mrs. Bejoy, have you prepared an index?
Yes, Your Honor. I was told that by the Part 1 lawyers that there is an index.
Well, I haven't got it. Could you please?
On page number 60. Yeah, I can get it sent out to the registry by email, Your Honor.
Well, if it's you mean you've tacked it on at the end of the bundle? Is that what you've done? Right.
Yes, it's there.
Okay.
It's at page 605 actually. At the end of the bundle.
What page does it start? And I will print it off for myself. You don't need to do anything.
605.
Really,
starting from 605, Your Honor.
Okay, thank you very much. Right, so here are the promissory notes.
Yes, Your Honor, you will see the first one on page 491.
Yes.
It's issued to the order of Snyder Prime Limited.
Yes.
It's the issue date is the 31st of July 2018.
Yes.
You can see the amount there, and it was actually signed. What I sent was draft copies, and I wasn't aware that anything got signed or not signed.
Yes.
But from what it looks like. It was signed.
They have been signed, yes.
They have, yeah, it looks like they have been signed. But you will see, when I send the email with the draft notes to Mr. Fakran, I believe it was beginning of April, 2nd of April, 2019, right? So, you know, the promissory note had almost matured by that date, okay? And obviously, at the end of 30th on the maturity date, on 30th July 2019, nothing was paid. This promissory note was not paid. And there's no other promissory note that I'm aware replacing it, okay? But that repayment happened in there with the provisions of the STA. In 4.2 clause of the STA, where 291,000 were repaid back to Snyder Prime, for which they must have an accounting entry in their bank account, and the 750 was with Kochi. So the point I'm trying to make is that, you know, these were subsequently signed, not when they were issued. They were signed just to make sure that, you know, all the documentation is in line with the obligation, with the amounts outstanding at the year end for the audit purposes, to have the proper audit trail.
Thank you very much. You've explained or given your evidence about these promissory notes with clarity. Thank you, despite the way they were put to you. Mr. Ghosh, is there anything else you want to put on the promissory notes?
One more question about the promissory note. Do you admit that these 3 promissory notes relates to working capital financing for SAM Precious Metals?
The Al-Shahir one does not relate to working capital for SAM Precious Metals because it was issued for a period of 6, well, the actual period when it got repaid was 6 days. So 6 days is not 5 years. And it's not dealt with in the STA agreement, or it's not shown at the end of their 2019 annual financial statement. So no, Al-Shahir was not.
So
The other two amounts we've already dealt with in part 3, A and B of my statement. I've already stated in my witness statement what I consider and my commentary. I mean, if you want me to repeat, I'm happy to repeat.
No, that's fine.
You don't need to repeat. I have the evidence clearly.
So kindly come to page 497. Just this is Al-Shahir promissory note.
Yes.
And the relevant page is 498.
Yes.
Paragraph 7. We hereby confirm that the above mentioned promissory note relates to working capital financing for SAM Precious Metals. So are you saying that this statement is wrong?
Well, in what context? Yes, it relates to gold provided to SAM for 6 days or 7 days, from the 30th or 31st to the 6th of January. That does not form part of the 200 kg. I mean, obviously, SAM Precious Metals has other sources of working capital. 200 kg is not the only working capital that SAM Precious Metals uses.
Okay.
Working capital, you know, also with investors, investment clients, working capital, etc. We tend to use, or you know, I've heard, and myself and everybody else, you know, in this hearing, and in general, we use terms which may mean different things to different people.
Okay. So
thank you.
Coming back to your witness statement, just 2 more questions, Your Honor.
Yes, well, I'll let you finish then.
Yes. In paragraph 7 of your witness statement, which is...
Sorry, apologies, Mr. Ghosh. Can you please remind me the page of my witness statement again?
Yeah, I'll tell you.
The bundle.
241.
Okay, thank you.
That's the relevant page where paragraph 7 is there.
Yes.
So I'll just read out. I was not advised by any of the parties involved in this gold client agreement that it had anything to do with the 200 kg of gold in the MOU, neither when I was asked to put a structure for it together in the aftermath of its termination, nor while assisting with the drafting of the STA in early 2020. Furthermore, it was a short-dated timeline, and the fact that it was laden with costs fully borne by claimant number 1 would have disqualified it on various grounds. Now, as a practice within the company.
Read the rest, Mr. Ghosh. Would have disqualified it on several grounds from purporting to serve as part of the 200 kilogram working capital with a lock-in period of 5 years referenced in the MOU.
Yes, yes. So as a practice, Mr. Skandalis, what was the practice of the company, whether it's the claimant or even the defendant number one, about delegating responsibilities? Because I'm asking this in the context of, you have written, I was not advised by any of the parties involved. Was there any communication verbally, or was it given in writing that Mr. Skandalis, you have to do this, or Mr. Acharya, you have to do this? So what was the practice?
I mean, normally it depends on we were at SPL level, and at some level we had conversations, WhatsApp chats, as normally colleagues or people that sit on the same board, communicate with each other in terms of using all the different means of communication. I mean, if you want to be more specific about something, then, I can shed light into it if I can, Mr. Goff.
Yes.
I think you've given your answer, which is that you communicate by various means depending upon the circumstances. Is that the position?
Yes, Your Honor. Yes, Your Honor. Thank you.
You have your answer, Mr. Ghosh.
Yes. Last question. Apart from a currency loan, if there is a gold loan, whether that qualifies within the bracket of 200 kg of gold?
Is that a question relating to some entity, or what is this?
Stop, Mr. Skandalis. I'm sorry, the question again is completely incomprehensible and is likely to produce an unsatisfactory, it's unfair in the first place, and is likely to produce an unsatisfactory answer because the witness can have no real comprehension of the meaning of the question. Will you please ask the question that you intend to ask in a comprehensible manner, Mr. Ghosh, so that it may be answered in a comprehensible and meaningful manner?
Yes, Your Honor. So we have two currency loans, which everyone knows. Mr. Skandalis has also mentioned in his witness statement. One is 1.04 from Snyder. The other is 4.9, I believe. So Al Shahir Gold was categorized under gold loan.
Where? By whom? Where? Please. What are you referring to? You make that bold assertion and statement without substantiation of it.
In the annual financial statements, Your Honor. And now
Thank you. Right, carry on. It was categorized in the financial statements as a gold loan, you say. Now, what is your question?
Question is, what is the purport, or what is the difference between a currency loan or a gold loan?
What's the difference between a currency loan and a gold loan in what context? I mean, as with everything else, is substance of the form. So what is the substance of, a gold loan or a currency loan? I mean, even by designating the name, normally if you say a gold loan, that means that it's made in quantity of gold. A currency loan is made in currency, or it may reflect the currency equivalent of a gold amount. Again, it's what the substance of the question is, and I don't understand the substance of your question, or what am I supposed to...
No, I understood what you said, so I've got your answer.
You got my answer. Okay. I'm happy that you did.
Mr. Ghosh, this really has been an exhibition of improper and defective questioning tending to mislead. And that last question was utterly pointless and wasting of the court's time. I really have to require you to focus on the manner in which you ask your questions and the purpose that you are asking them for, the answers that you are seeking, the suggestions that you are making. Please will you attend to these deficiencies in any further questioning during the course of this trial, or I will have to exercise the court's powers to prevent misleading, pointless, time-wasting questions. I don't want to have to do that, but this cannot continue as it has been this morning. You said to me that you were not feeling well earlier.
Yes.
I'm going to take a break now. If you are not well enough to continue, then you must let me know.
No, I'll just ask this. This is the last question, Your Honor. I'll
Very
just
well.
remodify this and ask Mrs. Scandalis. So, as
You
you're
have,
in the
you
annual,
have,
yes.
well, we'll leave it there for now. It's 22:02, is it, in Dubai?
Yeah.
So how long do you want for lunch, Mrs. Bijoy, Mr. Ghosh? Shall I resume? Is 50 minutes long enough? Resume at 2:30?
Yes, Your Honor. That is fine with me, Your Honor.
Very well. We'll resume at 2:30, and it will be your re-examination. Do you have any re-examination of Mr.
I do not have any re-examination.
Well, that's very convenient. So, Mr. Scandalis, I can release you as a witness. Your evidence is complete. Thank you. And if Mr. Garg would be available for cross-examination at 2:30, that will be fine. Thank you very much.
Thank you, Your Honor. Thank you.
Apologize, my lord, for.
Don't worry, Mrs. Bijoy. I'm just printing something off. Give me a second, will you?
Thank you.
Is Mr. Garg with us yet?
Yes, he's on the line, Your Honor.
Good afternoon, Your Honor.
Joining. Good afternoon, Mr. Garg. You're going to be cross-examined now by Mr. Ghosh and then re-examined by Mrs. Bijoy on very limited matters relating to evidence and materials filed since the last hearing was adjourned. I should tell you that you remain bound by the affirmation of the truth of your evidence. You don't need to affirm again, but it remains binding upon you. You understand that, I'm sure.
Yes, I do.
Thank you very much. So, Mr. Ghosh, would you like to begin?
Yes. So, Mr. Garg, regarding the Al-Shahir documents which you have produced, which shows apparently that the money was paid back to Al-Shahir on the 5th of January 2019. What was the interest amount which was paid for the 7 or 6 days it was lying with Sam Precious Metals?
So there was no interest amount paid on that investment.
And what was the reason for that?
So there were multiple conversations which were happening for the investment to be made, but the talks did not go through. So that is why within a span of 6 days, the gold was returned.
Okay. So previously you had mentioned that the promissory notes were not signed. So currently, if we look at those promissory notes, what is your view as far as the promissory note relating to Al-Shahir is concerned? I'll take you to that page and then explain. It is exhibit 20 at page 497.
Yes.
So it mentions that 31st December, date is 31st December 2018, and it's a period for, yeah. No, I'll take you directly to the next page at paragraph 7. We hereby confirm that the above mentioned promissory note relates to working capital financing for Sam Precious Metals. So what was the necessity of writing this when neither was there an interest component associated nor it was an investment according to the claimant?
So to the best of my knowledge, I had not seen any signed promissory notes, as I confirmed in my last witness. Once they were submitted by the defendants, this was the first time I saw them. And my submission here will be that I am not a party to these conversations, but I knew that there were talks going on with Al Shahir for this, but they never materialized.
Okay. So there has been a allegation from the defendant number 3 that whatever costs has been incurred by the claimant number 1 for these loans have been ultimately deducted from his JV consultancy fees. So his JV consultancy fees, you also know, I mean, it's an admitted fact as far as the MOU is concerned, is 10% of company net profit. From the first financial year, 2018, the total profit was, as per the financial statements which have been produced, which is in the previous bundle, 345,650 USD. So do you admit or acknowledge that 10% of this should have been gone to Mr. Shakti Chauhan?
So the JV consultant fees was paid according to the amount of gold that Mr. Shakti Chauhan bought in during that period on a pro rata basis.
Okay, so it was, according to you, it was not straightforward from the profits, whatever the companies incurred.
If we see the clause, it says for the services Mr. Shakti Chauhan will provide on ad hoc basis. So when the working capital has been bought less, the services required were less. That is why the treatment has been done the way it has.
Okay. So I'll take you to page 190.
I'm there.
Yeah, okay. Your Lordship, this is a conversation between Mr. Anuj Garg and Mr. Shakti Chauhan. This is Mr. Anuj Garg's number. So going below, there is a blue tick mark where it shows forwarded. As a clarification, the 10% of net profit is a fee paid to the JV company. So this has been forwarded by whom to you?
See, this number on top is mine, but I am not sure who forwarded this to me. I will have to check my WhatsApp, or if you can show me who forwarded this.
Okay.
There's a message from Dino as well.
Okay. So you agree that the clarification is 10% of net profit?
See, on WhatsApp chat, we discuss a lot of things. So there is no agreement or disagreement I can make. WhatsApp, if you see my WhatsApp, there are multiple groups, multiple chats, and we discuss multiple items during a day, which might change with time.
Okay. Kindly come to page number 561.
I'm there.
Okay. And this is also your number, and this is your WhatsApp chat with Mr. Shakti Chauhan again.
Okay.
So here you are mentioning new business plan, Win Imperial SAM, 2 million credit blocking channel with SAM. Now, this $2 million credit blocking channel with SAM was contributed by whom?
See, again, these are WhatsApp chats. I am not sure that if they materialized or not.
Okay. Even point number 3, this is also a forwarded message, as I can see. So probably you don't recollect who has forwarded this to you.
Yep.
What is your question or suggestion, Mr.
My question was, Your Honor, that this 2 million which is mentioned here, 2 million credit blocking channel with SAM, whether Mr. Anjgag knows, I mean, who is the party who has contributed this $2 million?
Where does it say there's anything's been contributed? It says 2 million credit blocking channel
with Sam.
No, what does the phrase mean? 2 million credit block in channel with Sam. What is the meaning of that? Do you suggest?
The defendant's stand is here. The suggestion is this is a 2 million which was already there from Wingold, in spite of the expiry of the agreement dated 26th August 2019 between.
So when is this dated? Where is the date on this?
This is 14th August 2019.
That's not the date. That's not a date shown on the forwarded message that you're relying on. I need to know if it's to have any impact at all, and it means absolutely nothing at the moment. When this message, this forwarded message, was created. Do you know?
No, I am not aware of that.
And what are you saying to this witness? What are you suggesting? 2 million
this
credit block in channel with Sam means?
The suggestion is this 2 million was lying with Sam Precious Metals as a contribution from Wingold through Snyder.
What do you say to that, Mr. Garg?
So there was an agreement for 6 months from February end 2019 up to August end 2019, and there was a 50 kilo gold which was lying with FAM on account of Snyder Global. So if it's the same agreement, then
during that period.
Yeah.
So,
okay,
this date, the only date we've got, the 14th of August, was that within this period of the 6-month VIN gold agreement?
Yes.
Now let me just read the message again, the forwarded message.
Your Honor, the clear picture will come at 563. There
Right.
it's written $2 million dollars is permanently blocked. So, Mr. Anuj, my suggestion relating to 2 million is permanently blocked is, in spite of the expiry of, though this agreement is 14th August, this continued even after 26th August.
So if I understand the word permanent correctly, it should have been on the books of the company in 2020, 2021, 2022, and so far. But there is nothing on the books as such. Secondly, I will again differentiate between the working capital introduced by or on behalf of Snyder Prime Limited, linking to the 200 kilo gold in the MOU versus the trading relationships that Sam Precious Metal had with multiple clients.
Okay.
Does that apply as well to Mr. Garg, to all these other completely unexplained references to Tijan, Mehul? Mehul is Vingold, I know. These are just ordinary trading relationships.
Yes.
Not the 200 kilogram investment of gold by Snyder Prime.
If I may, on page number 562 of the bundle.
Yes.
Point number 5.
Yes.
3 delivery in the week from Sam to Win. So if it was working capital permanently blocked, why would the company be delivering gold back 3 times in a week? So it was more of a trading cycle.
Very well.
So how did this cycle work? I mean, they were receiving money for how many days and delivery was happening in 3 days, right? I mean, how many days?
I can read in this is that 3 delivery in the week from Sam. So they were supposed to deliver thrice back. But I don't know if it materialized or not. These are conversations on WhatsApp.
Okay.
So I will not be able to comment on the materialization of these.
So, am I correct in saying that in the previous page 561, where it's written Sunday 1 million, Monday 1 million, till Saturday, these are the amounts which Wingold will pay Imperial against transfer someday, every day except Friday as follows? Are you referring to these with respect to the return in 3 delivery in the week?
So looking at this, I can understand it in a way where every day he would be paying a certain amount against delivery of gold thrice in a week. So he is purchasing gold from the company.
Who is purchasing gold from the company?
In the exhibit itself, it says Wingold.
So Vingold is purchasing gold from Sam.
Yes, but Your Honor, to be fair, I see one more client there, which is Imperial. So I'm not sure what the exact transaction happened, but it is a purely trading transaction that is happening. Money is coming in advance for purchase of gold.
Very well. Thank you.
Okay. So last question, coming to page 158.
Page number 158.
Yeah. I think there is a page 157 is blank. So page 158, yeah. Okay. So have you got it?
Who is this, Mr. Ghosh, involved in this?
This conversation in the group, Mr. Anuj, Mr. Sami, and Shakti Chauhan. These are the 3 people. The number ending with 3427 is Mr. Sami's, where he mentions that Mehul wants to renew the plan for 6 months. So congratulations. Hopefully Tijani will agree on the same terms, then we will celebrate. And your response, Mr. Anuj, is bravo. So did this transaction go through? After, I mean, Mehul, did he renew through for another 6 months?
Yes, this was so not renew for 6 months. So Mehul had a trading operation with Sam, and in annual financial statement, this 2 million is evidenced in AFS 2019, and it was trading purposes. My only submission here is that we have to differentiate between working capital coming for long-term investment from SPL versus the trading counterparties the company had. So this is a purely trading transaction.
Okay. So this trading purpose, according to you, happened after the agreement between Snyder Global DMCC and Wingold expired, because the date is September 25. So I assume that is the case, right?
We will have to check the exact dates on this because these are WhatsApp chats again. So exact dates I would not comment right now without having a look at the documentation.
Okay. Okay, Your Lordship, that was the last question.
Well, it's not for me to tell you how to do your job, Mr. Ghosh, but there's another statement that I've admitted in evidence with support documents. It's I think it's the 3rd witness statement of this witness, where he produces the annual accounts for the losses by the failure of the closure to close the Sharjah branch of 275,000 in the year 2022, 256,000 US dollars, and 2024, 105,000 odd US dollars, totaling $637,115. This is the claim in respect of the loss arising from the defendant's failure to cooperate in the closure of the Sharjah branch. Are you not challenging that? Just tell me if you're not, that's fine.
Mr. Garg, just one question from the Sharjah issue. Were you aware that there were emails, continuous emails from Snyder Prime Limited about the documents, annual financial statements relating to Sharjah branch, when this question regarding closure of the branch was discussed? Were you aware that all these emails were sent?
yes, there were emails and they were replied back to.
So are you saying that all those documents were supplied by the claimant?
So whatever the questions were asked and the documents that were asked, whatever the answers to them and the documents pertaining to Sharjah were supplied to them.
Okay. So my suggestion.
Mr. Ghosh, this was all material that was available to you in the first part of the trial when you first cross-examined this witness. Your liberty to cross-examine is limited to what has been placed before the court, not to go over old ground again since the hearing. What has been placed before the court in relation to this issue, the Sharjah branch issue, if I can call it that, is the quantification of loss calculated and brought up to date. Do you wish to cross-examine as to that or not?
Yes, just one question on this. Based on this witness statement, you have computed this loss 2022 and 2023. Now, did you produce any documents showing these exact amounts, like electricity bill incurred or rental payments, rental receipts, anything like that?
So Sharjah is a subsidiary for the company, and in the annual financial statements, the auditor has been supplied with all the necessary expenses document. That's why in the financial statements, he's come to those figures.
So those statements, those receipts are not part of this, trial bundle, I believe.
The actual invoices are not part of it. Annual financial statements are part of the bundle.
Okay. Thank you. That's all, Your Honor.
Thank you very much, Mr. Ghosh. Mr. Garg, I don't know whether Mrs. Bijoy has any re-examination following on that cross-examination. Do you have any, Mrs. Bijoy?
No, Your Honor.
Thank you very much.
I do not have any re-examination.
Thank you very much. Well, thank you, Mr. Garg, for coming again to give us your evidence. You are now released from this case and may go about your business normally. Thank you very much.
Thank you so much, sir.
Right. Now we go next to resume the cross-examination of Mr. Shakti. Mrs. Bijoy.
Yes, Your Honor.
If Mr. Shakti would come into the witness box, the virtual witness box.
Good afternoon, Your Lordship.
Good afternoon, Mr. Shakti.
May I commence, Your Honor?
Yes, please do.
Mr. Shakti, if I may please refer to your 7th witness statement, which is found on the supplementary bundle, page number 556.
Lordship, prior to that, no affirmation will be required for this new witness statement.
I'm sorry. Thank you for reminding me, Mr. Ghosh. Yes. Mr. Shakti, I should have reminded you, as I've reminded every other witness recalled, you have already affirmed to the truth of the testimony you have given in witness form and the oral evidence you've already given. You remain bound by that affirmation of truth, and you should remember that when you're giving your evidence. You do not need to make an affirmation again, but that is the position. So thank you, Mr. Ghosh, for reminding me of that oversight.
Thank you.
Right, so we're at the 7th witness statement.
Yes.
Where do you want me to look at?
Yes.
Or the witness to look at, more importantly.
Yeah. So, Mr. Shakti, if I may please request you to refer to paragraph number 5, which is found on page number 557 of the 7th witness statement.
Yes, I'm there.
And I see your statement that Win Gold is an investor and not a client.
A client can be an investor, and as investor can make client as well. The words can be used interchangeably, but I think you're referring to the investor contract between Snyder Global
Yes,
DMCC
I would
and
like you
Wingfold.
to refer to the gold investment agreement.
Sure.
And clarify after referring to the gold investment agreement, which is found on page number, if you may please hold on with me, on page number 212 of the supplementary bundle.
So just to read out my message,
Mr. Shakti, if you would please allow me to
directly jump
complete
into
my question, I would like you to
Go ahead.
refer to a couple of documents. One such document is the gold client agreement, which is on page number 243.
243.
I would also like you to refer to page number 212.
So 212, okay.
Which is for record 243 is the gold client agreement, and page number 212.
Yes.
Is the statement showing the interest calculations starting from the 1st of March 2019 to 26th of August 2019. And
yes.
Page number 217, which is a statement of account of SAM Precious Metal dated 27th of August. Would you agree with me, after referring to or reviewing these documents, that Wingfold was a client of the SAM doing gold trading, and all of these investments or the contributions recorded in the gold client agreement and the interest calculation sheet and the statement of account shows that the expenses for this contribution has been met by SAM?
Wingfold was a client of Snyder Global DMCC, and 50 kg of gold that it placed with Snyder was further deployed at SAM. And on that capital, it accrued interest rate, which was varied monthly. So if you allow me, on the page you have highlighted, I can take you to, first let's start with page 217. Right? Page 217, is your lordship there on that page?
Yes.
The section highlighted in yellow reads a credit of amount 113,554 has been credited to the account of Wingfold hedging account. The narration reads, being interest of USD 113,554 transferred from the account of Snyder Global DMCC to Wingfold. Right? So this is showing that the credit came here from Snyder Global's account. Now, let's see where it came from. If your lordship could go to page number 216 of the bundle. Are you
Yes.
there?
Yes.
On page 216, the last row that you see, it says, being interest of USD 113,554 transferred from the account of Snyder to Wingfold. So you can see this number 113 appearing on the debit side of US dollars, right? And this 113, how was this accrued in this account? There are rows from 2nd to 7th where the narration says interest charge, and each row is an interest for a month. I'll later show how this interest was fixed. But you can see the second row item is equivalent to 21,352.
Sorry, say that again. So 21,352. Yes. Yeah.
Yes. The row of the third row is 20,561. So you can see every month it is changing. right? But these are the amounts that were totally added up and roughly amounted to 113,000, which was transferred. I will take you to the exact calculation where on Sam's account statement, it is basically varying a monthly interest rate, Your Honor. So if you could go to page number 212, I think that's what Ms. Bijoy referred to. Are we there yet?
Yes.
So some quick observations. Second last column from the right says INT rate, that's interest rate, right? So you will see that this interest rate is fixed for every month. So when you're deploying capital in terms of a liability, you can set your rates on monthly basis or annual basis. If you were to scroll through this page, you will see it stays at 12% until the middle of second page for the month of March and April. And if you look at page number 213, you can see from month of May, it was varied from 12% to 7.8%.
Yes, I see that.
If you further scroll down, you will see from 1st of June, the interest was varied from 7.8 to 9%.
Yes, I have that.
And yeah, and subsequently for every month, they set one fixed rate. It's 10.2 for July. And I think for August, it's 12.6, right?
It goes up again in July
yes.
2019. Yes, I see that.
While I'm not aware to what was the reason behind resetting the rates on monthly basis, I can show you that each row is a daily interest calculation, and which is calculated by using this interest rate. So if you could, if I could request your lordship to come back to page number 212.
No, I won't, because I want you to answer the question you've been asked.
Yes, so the answer is, yeah, this is an interest rate, and that's why the sheet is saying interest calculations, and the interest is calculated on daily basis.
Just
and
stop.
If you see the right.
Stop. Will you please ask your question again, Mrs. Bijoy, and you, Mr. Shakti, will answer it. Ask your question again.
Yes. So going back to the documents that I have referred to in my question, I have introduced to you the client gold agreement.
You don't have to, Mrs. Bijoy. Just ask the question.
Yeah. So my question is, what is the nature of the contribution from WinGold?
That's a different question. That's not the question you asked when you introduced these documents. It was, do you agree WinGold is a client of SAM for gold trading purposes?
Yes, yes, Your Honor.
Or something similar. So what question do you want to ask? Now you have taken me to the documents, and Mr. Shakti has given his explanation of what these documents show. What is your question, please?
Can you explain to this court why interests were paid to WinGold on these investments, on these contributions?
Yes. So interest was paid from SAM to Snyder DMCC, and then subsequently from Snyder DMCC to WinGold. And this interest was paid on capital.
You have not answered my question, Mr. Shakti. If I may please interfere, can you please answer me why the interest was paid?
It's a liability. It's working capital deployed from WinGold to Snyder, Snyder to SAM, and that's why the interest was paid. Anytime you allocate capital, there is an expectation of return. In this case, there was an expectation of an interest which was reset on monthly basis.
Okay, so you agree with me that this interest will be calculated on a daily basis?
And interest was reset on monthly basis. However, these accounts are showing you that it was accrued on daily basis. So you can take monthly interest divided by 30 days and you'll arrive at a daily accrual. So that is what 212 page number is showing to you.
Okay, I have a follow-up question on that. Now, who will be bearing these interest? Is it Snyder or is it SAM?
It is Snyder that ultimately paid, and if not Snyder, then it was deducted from my JV fees. So if you see in
Stop, please, Mr. Jahan. You're not doing yourself any good service here at all by evading answering the question. Who ultimately paid the interest that was paid to Vingold?
Shakti
You've
Chauhan
already,
in his personal capacity. Yes, I paid for it and it was deducted from my JV fees.
so that's what you're saying. But this
Yes.
money of 113,000 odd, I understood you to say a moment ago, it was paid from Sam through Snyder to Vingold. Is that correct or not?
Yes, Your Honor, and it was deducted from
Wait
my
a
annual.
moment. That is not the question you're being answered. You asked to answer. You, I know, have a case that you paid for this by way of a deduction from your consultancy fees that was effected by Sam. I know that is your case, but that is not the question you're being asked at the moment. The question is, first of all, who paid this interest? And the answer to that is Sam paid the interest
Sam paid for the interest, yes.
to Snyder,
Snyder.
and it was paid on from Snyder to Vingold that had made the investment. Now, I'm well aware you have a case to say that in order to reimburse itself, Sam deducted money from your entitlement to your consultancy fees. I'm well aware of that, but this is a lesson you need to learn. You're not being asked about that at the moment. You've had your opportunity to put that forward. You've just heard me recite what your evidence is on that. You know that I know what your case is on that. You do not need to keep berating me with it. Do you understand, Mr.
Yes, Your Honor.
Shakti? So will you please try and answer the questions? Be assured that I am in full possession of the case that you've put forward in the evidence that you've put forward. I've no doubt that Mrs. Bejoy will be asking you about that deduction and the basis on which it was made in due course. You will have a chance to say again that you were paying for the cost of this financing. Please, I've taken a while to explain this to you in forceful terms because it's necessary in circumstances where you seem to think you are entitled to sit there and make speeches about your case. You are not. You have given your evidence in witness statements, in your pleadings, and your counsel will be able to make submissions about it. What you are there to do at the moment is to answer questions. And it will be detrimental to your case and the impression you make on me as a witness if you carry on in the manner in which you are presently carrying on, constantly seeking to make out your own case with speeches. I know what your case is. So please listen to the question. I appreciate sometimes that they're not asked in a concise manner. Listen to the question, formulate your answer, give me your answer, and don't make a speech about your case. Is that clear?
Yes, Your Honor, it's clear.
I hope I don't have to intervene again. Right, Mrs. Bejoy. That puts you as well under an obligation to make your questions clear and concise.
Yes, Your Honor. Mr. Shakti, if I may please ask you to refer to page number 235 of the supplementary bundle.
Yes,
Are you on page number 235?
Yes, I'm there.
As you can see, this is a letter issued by Snyder, which states that addressed to, it says that the agreement dated 26 February 2019 between Snyder Global DMCC and Vingold expires on 26th of August 2019.
Yes.
Do you agree with me that the arrangement between Snyder Global DMCC and Vingold expired on the 26th of August 2019?
Yes, this investment contract expired for 6 months.
Thank you.
After 6 months, yes.
I would now like you to refer to the second paragraph in that same letter, which reads, as per Wingold's instruction to Snyder, please pay all inclusive accrued returns to Wingold. Also, transfer Wingold's investment from Snyder Global DMCC account with Sam Precious to Wingold's account with Sam Precious. Do you agree with me that these are the returns that we have visited on page number 212
from 212
and 217 of the supplementary bundle?
Yes, for the first 6 months, those are the ones. Yeah. Directly paid from Snyder to Wingold.
I think you said then paid.
Page 212.
Wait a minute. Paid by Snyder to Wingold. It's paid. This is a direction by Snyder to Sam to pay the returns to Wingold. That's correct, isn't it? It's not Snyder paying the returns. It's you or Snyder directing Sam to pay the returns direct to Wingold.
Yes.
No, I'm not asking you, Mrs. B. Joy. I'm asking the witness.
Sorry, Your Honor. Apologies.
Yes, Your Honor. And that's why on page 217, you see a credit in Wingold's account and an equivalent debit in Snyder's account for
yes.
$113,000.
You've taken me to that, and I've seen it. But I think you misspoke when you said Snyder paid this to Wingold. It wasn't Snyder, it was Sam that paid it.
Yes, Sam bore the cost for the duration. And the way it paid was Sam paid to Snyder and Snyder paid to Sam. So effectively, Sam paid for it, yes.
Right.
I suggest to you, Mr. Shakti, that the 2 million odd amount contribution from Wingold is only a trade-related contribution and not a working capital contribution as per the terms of the MOU.
It's the investment deployment. And if you look at the last page, which we're currently on, page number 235, I think.
Mr. Shakti, if I may please ask you to pause, you can agree or disagree with me first and then go on to your explanation.
Yes, I disagree that it's a trade deployment. I was and actually because we're on the same page where the investment is mentioned. So can I take you there, or is that the?
You can refer. Yes, you can refer to the document if to substantiate your answer of disagreement that it is trade related, and your case that it is an investment in accordance with the MOU obligation to invest 200 kilograms of gold. Yes. What do I look at in this document that supports your case that this is part of the provision of 200 kilograms of gold investment in accordance with the terms of the MOU for 5 years?
So the last sentence, Your Honor, reads also, transfer Wingold's investment from Snyder Global DMCC account. So my response to Ms. Bijoy's question is trading capital, right? Here it is referenced as investment capital. Investment capital in different tranches were deployed directly from Snyder or from its associated entities. And in this case, this 50 kg was deployed from Wingold to Snyder and then from Snyder to Sam Precious Metals. And if you add up all of those facilities at any point of time,
you're making a speech again. You must desist. You're being asked about this. I have your answer that this is referenced as investment capital going from or arranged by Snyder from Wingold to Sam and being transferred after the agreement to Sam. That is the limit of your answer. Permissible answer. Right. Mrs. B. Joy, move on, please.
Yes, Your Honor. One more question that I have on that point. Would you also agree with me that by virtue of the letter dated 26th of August 2019, which we found on page number 235, the investment, the contribution from WinGold stayed only for a term of 6 months and not for a term of 5 years as agreed as per the MOU?
It stayed for more than 6 months. For how long, I am not aware of that. But if you remember, what we have already explained is, I've shared a version of Sam's draft 2019, where WinGold is still showing at the end of 2019, right? So the investment contract of WinGold to Snyder ended in 6 months. But after that, direct deployment of $2 million happened from WinGold to Sam. And this can also be verified in a WhatsApp message, which happened between Sami Abu Ahmed and myself after the end of the contract. And if you allow me, I could take you that in one of the exhibits.
No, you will
required.
not. You will not.
Okay.
I have got your important answer, which is that though this particular investment contract ended after 6 months, by reference to the last sentence you've highlighted here, what you say is that after it ended, the money then, Vingold's money, then stayed with Sam Precious Metals, and you don't know how long for.
Yes, Your Honor, that's my answer.
That is your answer, and that's
Yes.
the limit and total of it, of what's relevant. I hope we're getting there with an understanding of asking questions and giving answers to questions, please. Or we'll be here for another 3 weeks, not 3 days. Mrs. B. Joy, please
Yes, Your
continue.
Honor.
I don't think that's an authorised participant I've just heard in these proceedings.
No, Your Honor. I'm sorry for that.
Trouble. I'm a dog lover.
Yes,
Carry on, Mrs. B. Joy. A bit of
Yes.
light relief is sometimes entirely appropriate.
Yes,
So
and
carry on, Mrs. B. Joy. Your
Yes.
next
two in
question.
number, actually.
Mr. Shakti, would you agree that Kochi Global Trading LLC is a company owned by you?
It was owned by me until 2021.
What was the name of the company again? I didn't quite catch it.
Kochi, Kochi.
Oh, yeah, Kochi. Yes, I know about Kochi. Don't trouble to explain what it is. Yes, I just didn't hear you properly. Carry on.
You agree with me that Kochi had trade relationship with the first claimant?
Yes.
Would you also agree with me that as per the STA, which is found on page number 91 of the old bundle, STA is starting on page number 87 of the old bundle, but I am referring to clause 4.2, which is found on page number 91 of the old bundle.
Just give me a second. Let me quickly open it. On page number, you said, Ms. Bijoy?
Page number 91.
I don't think I have the old bundle. I can open the other version of the STA, but if you could just highlight which clause you're referring to, I would know.
Clause 4.2.
The STA. Yes, I'm looking at clause 4.2 now.
Yes. The balance payment of USD, I'm reading from clause 4.2, 750,000 will be offset against a company receivable from Snyder affiliate. Would you agree with me that the Snyder affiliate referred here is Kochi Global Trading LLC?
No, I don't think it says Kochi Global Trading LLC.
That is why I'm asking you. So, because Snyder affiliate, you should be knowing. So I'm asking you, which is the Snyder? Are we referring to Kochi Global Trading LLC in clause number 4.2?
Company with just allow me to go through it. Company. Yes, I think it's fair to assume it's probably Kochi Global. It's fair to assume. I don't see Kochi's name anywhere in the agreement, but you know, I'm assuming there's a follow-up question for that.
I think the point that's being made is that this investment of 1,041,000 odd working capital was repaid to you, to Snyder, I should say, in the form of two amounts, $291,711 following the share transfer, and the balance, in effect, was settling a debt, paying off a debt owed to the company, Sam, by Kochi, one of your, a company that you owned, or here it's described as an affiliate.
No, Your Honor. There was no debt. A share transfer agreement was a variation of the MOU, the non-binding MOU. And at the time of STA,
you misunderstand me. The balance of 750,000 will be offset against a company receivable, that is a debt owed to the company Sam by a Snyder affiliate, and you've agreed that that's probably Kochi.
That is probably Kochi, yes.
Right.
But so, if you can I elaborate on this, Your
well,
Honor, if you allow?
You can elaborate to the extent of explaining what was going on here.
Yes, Your Honor. When the STA was signed, all the parties involved.
Mr. Shakti, it would be really helpful if we can talk more about the relationship between Kochi and Sam, because I think we have no questions raised on the STA. The clarification that I'm asking you is the sort of the relationship that led to the debt of USD 750,000. If you could please clarify that to the court, please.
Sure. So Kochi has a trading relationship with Sam, and as an activity of trading, there are creditors and debtors. So sometimes Kochi would give it gold and would receive payment next day, or sometimes it would receive payment and a balance amount of gold would be delivered the next day. So it appears that on this particular date, there was an obligation, means there was a trade payable of the amount is $750,000 of $750,000 that was to be paid from Kochi to Sam, and that was offset as all the books were being cleared up against the convertible loan of 1.04 million from SPL to Sam.
Yes, thank you. That does explain it and answers the question. Thank you.
Thank you. Now, moving on, Mr. Shakti, do you agree with me that Rosie is a preferential shareholder in the first defendant, that is Snyder Private Limited?
Yes, Snyder Prime Limited.
And Snyder Private Limited had several transactions with Rosie.
Not several transactions. There was actually no banking transaction. It was just at the time of issuance of preferred shares. That is when Rosie was brought in. And and there are no transaction actually that I can even remember.
So other than being a preferential shareholder in Snyder, there were no transactions whatsoever, including trade transactions with Rosie?
None.
You agree with me that the currency loan of US dollars 4.9 million provided by Al Asil was guaranteed by Rosison?
Snyder was obligated to arrange 200 kg, and as a part of the responsibility, the preferred share owner of Snyder Prime Limited, which is Anuj Garg, who's also the shareholder of Rosison, arranged that facility.
So was it guaranteed by Rosison?
I am not aware of that. There was no document that I've seen, but Snyder Prime paid an interest to Mr. Anuj Garg for arranging this facility. Because, Your Honor, when you say guarantee, it amounts to what's the documentation behind it, and there was no documentation to that effect. Only documentation was Al Asil deploying $4.9 million with SAM.
Very well.
Mr. Shakti, if I may please ask you to refer to old bundle, page number 88, which is the share transfer agreement.
I'm going to open the,
Yeah.
Sorry, go ahead.
Yes, are you there at page number 88? Do you have the STA with you?
I have a standalone STA with me, but if you can guide me, is it the recital on
Yes.
page number 2 you're referring to?
Yes,
I'm there.
on page number 2, inside page number 2, recital is clause number 7.
Yes.
It says, Rosie further arranged through its associates and affiliates the provision of a working capital facility with a face value of US dollars 4.9 million to the company for the purposes of facilitating the operation of the business.
Okay, yes, I can read that.
What's your question?
My question is, you have in your earlier question clarified that the facilities were not arranged, or rather you are not sure whether Rosie arranged for these facilities. So how would you respond?
I said they did not guarantee. I said Anuj Garg, as a preferred shareholder of Snyder SPL, also as a shareholder of Rosison, arranged those facilities. That is what I said.
That's exactly what he said, Mrs. B. Joy. The point about guaranteeing, which I think it was you that raised it. It might have been me. He wasn't sure about that. He's not seen any documentation. Did you actually suggest that Mr. Garg had guaranteed this facility? Did you suggest that, Mrs. B. Joy?
Yes, I would like Mr. Shakti to comment on the suggestion.
Right. Well, he's already answered that question. He said he doesn't know because he's seen no paperwork between Al Asil, as it was, that provided it, and Mr. Garg, who arranged it. So the question has been answered.
Yeah. Grateful, Your Honor. Mr. Shakti, would you agree with me that around 2019, Mr. Anuj has communicated to you that, or rather Ms. Rosie has communicated to you that they would withdraw their support extended to Al Asil for arranging the financing to SAM for the 4.9 million?
Anuj had communicated, because 2019 Rosie was nowhere in the picture. Anuj had communicated that he would like to have a part shareholding, else he would pull the financing line through Al Asil. Rosison did not enter the picture until I think 2020 February.
Okay, thank you. And when this was communicated to you in 2019, you knew that the claimant could not operate without gold working capital.
Yes, the refinery requires a working capital facility.
Do you also agree with me that in 2019, when this facility was to be pulled off by Mr. Anuj, you could not arrange an alternative currency loan equivalent to USD 4.9 million to substitute the original commitment from Al-Asil?
His request was to transfer the shares to him. So if Snyder transferred, so originally Snyder owned 50% of SAM. If Snyder transferred 25% of those to Anuj Garg or to one of his entities, and that is how Rosie Sun was introduced, Asil would continue to finance, and that was the settlement that was ultimately reached.
So you agreed for this because you could not find any other alternative for the working capital.
So yes, December 19, if you see, was COVID onset, right? And by January, I think it's easy to understand what the situation around the world was. And at that point of time, the only resolution that we could find was that Snyder would transfer 25 out of 50% of his shares to Rosie Sun with a buyback clause, right? And the idea was
don't go into the buyback clause. That was not actuated. It's not relevant to this question that you've just been asked. The question was a simple one. When Mr. Garg indicated to you in 2019 that he wanted to withdraw his support for the existing finance facility of 4.9 million, which implies that he had supported it in some way, whether by guarantee or other arrangement, when he indicated that he was going to pull it, as the expression that's been used, the simple answer to the question is you were not in a position to replace that equivalent of gold finance at that time. Is that correct?
Yes, Your Honor.
Thank you. Mrs. Bijoy?
Yes, Your Honor.
Your next question, please.
Yes. Mr. Shakti, you would also agree with me that it was to settle Anuj's outstanding, or rather Rosie's outstandings, and to adhere to your gold commitments as per the MOU that you have then entered into the STA and transferred 50% of your shares in the SAM Precious Metal to Rosie Sun.
For $4.9 million of deployed capital.
Mr. Shakti, right? If I may please.
Yeah, Mrs. Bijoy, you're interrupting him now. Let him finish, please.
Yes, Your Honor, please. Sorry.
$4.9 million that was deployed from Al-Asil to SAM was accruing an interest rate annually at the rate of 30%, right? And the verbal agreement between myself and Mr. Anuj was that at the time of exit, and there is no written agreement to that effect. At the time of exit, whenever we would be able to do a share exit from SAM Refinery, we would be able to give him an exit price. But given the onset of COVID, he was concerned about how the global situation was changing, and he asked us to transfer the shares as per the STA. Now, STA just doesn't mention one part, right? There are several clauses, and they all operate in tandem. And some of them I will not visit in light of what Your Honor has guided me. But STA has number of clauses to it, which together were executed.
So to follow up or to summarize, you would agree that it was in order to meet the financial obligations to Rosie and to perform your obligations under the MOU that you have entered into the STA and transferred 50% of your shareholding in SAM Precious.
Yes, to make sure that the refinery doesn't blow up, that was the ask of Mr. Anuj Garg under certain commitments, right? And without going into what those commitments are mentioned in the STA, which the defendants would satisfy. So in order to make sure that the working capital is not pulled out and the company doesn't, have a sad outcome, Snyder and I agreed to sign that STA.
Very well, thank you. I have that answer. You were the important thing is that you were honouring in this way, as you believed, part of your commitment under the MOU to the tune of preserving this 4.9 million in the business, as it were.
Yes, Your Honor.
Let me ask you a question there, because I have to decide this, so I'll ask you directly while it is really to the fore. You did that presumably because you regarded yourself as bound by the terms of the MOU to do so, did you?
I was concerned about the future of the company. If there is no working capital at that point, the company, there is no existence of SAM from that standpoint. So my primary concern was that, and given, if you see, 5th February is when we signed, right? It's like peak COVID.
Mr. Shakti, I'm giving you a chance to answer the question straightly, quite easily. Did you do that because you considered yourself bound by the terms of the MOU to do so? Yes or no?
No, Your Honor.
Thank you. I have your answer. Carry on, Mrs. B. Joy.
Yes, Your Honor. Mr. Shakti, can I ask you to please again refer to clause number 4.2 of the STA, which is again on page number 91 of the old bundle?
So, yeah, I have a standalone version of STA. I'm looking at clause number 4.2.
Yes, I would like you to please read out the last line of clause 4.2, which reads, Snyder will provide the company with 100 kg of gold by 31st December 2020 to be maintained in the company to a final term of 5 years from the original commencement of company's operations.
Yes, you've already read it a lot. Would you like me to repeat the sentence, you mean?
No, I have a question on that.
Sure.
Can you explain the reference of this 100 kg gold and the reference of the 5 years term, which is going back to the original commencement of the company operations? Are these two terms taken from the MOU?
As I understand, ST is a variation of the MOU. So some of the terms are, variation of those terms or similar terms in the MOU.
So you are saying those are similar terms of the MOU?
Yes, that's what
Meaning it could be one and the same?
Yes, it could be one and the same. Excuse me.
I would now please refer you to the MOU on page number MOU found on page number 180 of the old bundle.
If you could tell me what clause we're looking at, I can look at the.
Yes, I am looking for the clause, please. If you could please bear with me for a minute. The clause that I'm referring to is on page number 185 of the old bundle, inside reference number, page number 6 of the MOU.
Yes, I'm there.
Precisely, I'm referring to the clause lock-in period, lock-in. And it reads, the first party and the second party agree that they shall not sell any of their shares in the JV company for a period of 5 years from the date of the execution of the definitive agreements unless otherwise agreed by the parties in writing. Now, my question to you is, when you transferred 50% of your shares in SAM Precious Metal in 2019, did you not breach this clause of the MOU?
Mrs. Bejoy, are you really suggesting that this was a breach in terms where the other parties or at least... Or
rather, I would like to rephrase the question, Your Honor.
Well, I thought you might want to rephrase it because
yes,
this clause in the MOU, whoever was owed the obligation, was a party to the STA and plainly agreed to the transfer of the shares.
Yes, so I would like to rephrase my question. That your transfer of shares in 2019
2020, you mean?
Yeah, in 20. Was to give comfort to the second claimant who accommodated Rosie as a new shareholder despite the existence of a lock-in period clause in the MOU.
So the shareholder in SAM is not Shakti. It was never me, right? It was Snyder. And Snyder transferred its share, and that agreement is signed by Sammy as well, right? And if you see, I think what you're reading is last line says, so execution of the definitive agreements unless otherwise agreed by the parties. And so all the parties, as of this line, they agreed.
Yes, to the parties to the MOU are Mr. Sami and Snyder. So my question to you is, when you transferred the share in 2019,
2020.
Sorry, 2020, or your...
Mrs. Bejoy, would you like a few moments to try and formulate this question? Because at the moment we are just wasting time with imprecision, ill thought out questioning. You plainly have some point to make here. It seems to me it's on the basis that there was an agreement by some means to waive the lock-in period between some parties for the purposes of the share transfer agreement. So would you like to take a 10-minute break and just think about what you want to ask or put to this witness so that we can have a coherent question with a purpose and a coherent answer, please? I'll adjourn for 10 minutes. Well, should we take a mid-afternoon break, we'll call it? It's 3:45 there, I think. Is it 3:45?
Yes, Your Honor.
Let's resume at 4 o'clock and then we'll finish the day through to 5 o'clock.
Thank you.
Yes, good afternoon again. Is Mr. Shakti available?
Yes, Your Honor, I'm here.
He's coming now, right. So, Mrs. Bejoy.
Yes, Your Honor.
Would you like to ask a question, please?
Yes. So, Mr. Shakti, would you agree with me that there is no clause in the STA that says that the MOU is superseded?
I don't think so.
Mrs. Bejoy, I'm really in despair here. I can read the STA. I don't need a witness telling me what is and is not in it. This is not how a trial is conducted, asking barn door obvious questions for an answer which is equally barn door obvious. The question of whether the MOU prevails is a matter of construction and interpretation of how the two agreements interact. And I made that plain to you both at the start of these proceedings.
Yes, I'm grateful for the
Carry on, move on, please, to a different question.
Mr. Shakti, you would agree that as on 31st December 2020, you failed to bring 100 kg gold as per the MOU.
Yes.
Would you also agree with me that the claimant, Sam, has suffered loss due to your breach in bringing the 100 kg gold?
No. Just to clarify, there's always been 200 kg there. I think, are you saying that 100 kg has not been at SAM since 31st December? Because the 31st December resolution made sure that the other claimants put that allocation in, right? And as we've gone through 2018 and 19, I think everywhere we have argued that 200 kg was there. So I think to have a loss first, you have to establish that 200 kg was not there at SAM.
I'm sorry, I thought, Mr. Johan, maybe me this time. I thought you agreed that you failed to bring in 200 kilograms of gold. Wasn't that the question you put, Mrs. Bijoy?
Yes, Your Honor.
And
No, Your Honor. I think Mrs. Bijoy asked if we failed to bring 100 kg. Because 100, right?
Yes, my question was 100 kg, not 200 kg. 100 kg as on 31st December 2020.
You mean in accordance with
the MOU?
Not the, you're confusing matters again.
As per the terms of the STA and MOU, if I may please refer so, state so.
Just pause a moment. The MOU required the provision of 200 kilograms of gold, etc., upon certain milestones occurring. And
yes, Your Honor.
To be there for 5 years. It's the STA that provides for an obligation, let me finish, an obligation to bring in, and clause 4.2, we've just been looking at it, 100 kilograms of gold by the 31st of December 2020. And you're asking, did you fail to bring in 100 kilograms of gold by 31st of December 2020? And I understood the answer to be that you agreed, Mr. Shakti, that you did not bring in 100 kilograms of gold by 31st of December 2020. Is that right yes. or wrong?
If you allow me to elaborate, Your Honor.
Is it right you accept you did not bring in 100 kilograms of gold in accordance with the share transfer agreement by
yes.
31st of December 2020?
By 31st of December, yes, we did not bring.
So again, Mrs. Bijoy, you framed the question by reference to an obligation under the share transfer agreement, and then you start talking about the MOU, which is not only confused me, it must have confused the witness as well, because he's just had to elaborate to say that, again, reiterating his case, that there was the 200 kilograms in the claimant, the first claimant company, from the time of the MOU in the way in which he is contending that obligation was satisfied, with these trading amounts from such as Vingold and the 4.9 million and his own contribution and so forth. So you need to ask your questions much more precisely. Otherwise, we get this sort of confusion. So let's start again, shall we? Ask the question that you first asked on this line.
Yes, Mr. Shakti. My question to you is, as on 31st December 2020, you failed to bring 100 kg of gold as per the terms of the STA.
Yes.
Thank you.
You also agree, I may then move on to the next question. Although I did ask, I will repeat that question also for record. My question is, would you agree with me that the first claimant, Sam Precious Metal, has suffered loss due to your breach in bringing 100 kg of gold?
Ms. Bijoy, there was 100 kg already at the refinery, and for that, we paid a cost for it, right? The agreement states that Snyder has to replace that facility. So there was no loss or loss of profit at the refinery level. The STA states that Snyder had to bring, right, so that the facility infused by Sammy and Anuj could be taken out. So there is a resolution to that effect where Sammy and Anuj had deployed capital between June of 2020 until December of 2020. And then there is another resolution where they deployed 100 kg from December, from 1st January 2021 till now, as I understand. So because there was no lack of gold, therefore there is no question of loss, loss over there. However, separately, that facility should have been replaced by 100 kg from SAM. So that's from Snyder. That's a separate matter. That Snyder's in breach of.
Okay. Now moving on, I would like you to answer me a couple of questions on the below topic. I'm moving on to another topic. Before I do that, I just wanted to have one more question with you in relation to, if you may please hold on. I would like you to please have a look at page number 218 of the new bundle, of the supplementary bundle.
Give me a second. 218, yes. Yes, I'm there.
As you can see, this is a world check report on Mr. Mehul Nanda.
Yes.
And there is also another world check report on Vingold, which you will find on page number 224.
Yes, I'm there.
And if I recall, in your earlier witness evidence, you have stated that Vingold is having a negative in the world check report.
Yes.
Do you agree with me that as per the reports that I have just referred to you, that there is no negative entry against Vingold or against Mr. Mehul Nanda?
What was communicated to me by Sami Abu Ahmed is that Vingold appears in the negative checklist. And I have that evidence over WhatsApp and over audio message, right? So I don't operate the world check system. I rely upon the directors of the company in which Snyder has invested, or directors of other companies where I might have been an ex-shareholder. So we rely upon their judgment over this. So what was communicated to me was, and if you want, I can get more into this detail, due to what issues there are negative implications, which is predominantly around a separate case that has been filed, and I would like to respect his lordship's guidance that that I'm not supposed to go in that area. But yeah, this was communicated to me by the directors of the company.
So you're telling me that you didn't yourself discover that there was an adverse report against Vingold or Mehul. You're telling me that you were told that by Sammy.
Yes, and I have that, and the reasons also I have it over voice, audio message, or WhatsApp messages. If Your Honor would like, me to submit those.
I'm not going to receive any further evidence at all in these proceedings that are being bits pulled out like rabbits out of a hat. I will make my decision as to whether you're telling me the truth about this or whether you told me a lie about Vingold. You really, this is not a jury trial, Mrs. B. Joy. These are points that you can make in submissions about Mr. Shakti's credibility, and I will weigh them. I've now got his answer. He says he was told by Mr. Sammy, and I will have to make a decision on that.
Yeah,
End of subject, end of cross-examination on this. Please move on.
Yes, Your Honor. Mr. Shakti, if I may please now refer you to one old bundle, page reference number 193.
Can you send me the operative document you're looking at? I'll try to see if
Yes.
I can just download
Yes,
that.
just give me a minute. This is a board of the directors meeting resolution dated 19th of September 2021.
Okay, I'm actually downloading the full bundle right now as you speak, but if you could read out the contents of it to me. 19th September 2021.
Yeah, so the point that I wanted to...
Yes, I have that in front of me now.
Okay. So you can look at the board resolution because I have a question on that. My question is, would you agree with me that the resolution of the first claimant was signed by the authorized representative of the first defendant, Snyder Prime? And it contains...
let me just see. Yeah, let me just see who else
reference
have
to
signed over
Sharjah
there.
closure.
Yeah, Konstantinos Skandalis is there. Yes, I believe he was a representative of S. Snyder at the time.
And what do you want to draw his attention to and ask about in this resolution?
Yeah, on the reference to the Sharjah relocation closure, which is towards the middle of the resolution. Further, it is resolved towards the middle of the page. You can read, the company will relocate its branch in Sharjah and Dubai, UAE, move both Sharjah and Dubai branches under one roof in Dubai Production City, where company has signed a lease and applied for approvals to commence renovation work in the new warehouse.
And what is your question?
The question is whether this is a board resolution that has been signed by the authorized representatives of the first defendant, Snyder.
Right, he's answered that, so move on.
Your Honor, if you allow me, this is a directors. If you go to the top of the resolution, it says Board of Directors meeting.
Yes.
Right. So it's signed by the directors of SAM. I think the question Ms. Bijoy is referring to, there's a elaborate email communication between SAM directors and Mr. Dino, where Mr. Dino explains that shutting down a subsidiary is a shareholder reserve matter.
I've seen all of that, and you don't need to go there again.
Okay.
We've had all of that evidence. But your point is well made that it is signed by Konstantinos Skandalis in his capacity as a member of the board of SAM Precious Metals. That's the point you're making.
Yes, sure.
Yes.
Although he was the representative of Snyder on the board at that time.
Yes.
I have that, and all of those points could be made without any questions at all by reference to the documents alone. Yes, Mrs. B. Joy.
You would agree that operating a larger refinery with a capacity of 3 refineries in one location would be more efficient than operating 2 refineries in multiple locations.
As you're aware, we've not seen financial statements for a long time. So the internal workings has been an issue of debate between the shareholders. So I could not comment on whether combining together would be more effective or not. And I think to your point, that's a silver refinery, from what I understand. And Dubai is a gold refinery. So I think you're referring to combining you're talking about the efficiency of combining a silver refinery with a gold refinery, about which I'm not a subject area expert.
Okay. That's all, Your Honor. I do not have any further cross questions.
Right, thank you very much. Mr. Ghosh, do you have any re-examination?
No, Your Honor.
Thank you very much. Thank you very much, Mr. Shakti. Your evidence is complete, and you may leave or observe as you wish. You can certainly turn off your camera, and thank you for assisting us in this case.
Thank you.
Good day to you.
Thank you very much. Cheers.
Right, now back to our schedule.
As per the schedule, we are to commence the cross-examination of Mr. Mahmood Fakran.
Yes.
Yes.
So will you call Mr. Fakran, please?
Yes. I will.
Just take me to his statement, please, will you? In the old bundle.
Yes.
The page reference. I know you're going to get him to prove it, but I'll have it to hand while he's getting plugged in.
It's at page 530.
Thank you very much, Mr. Ghosh.
So let me call him. He's joining.
He's made just the one statement, hasn't he?
Yes, just a one witness statement. So tomorrow morning, I believe it will be over today, and tomorrow morning we'll have the expert then, right? Or no, it will not be over today.
Well, I'm waiting for an update on that from Mrs. Bejoy. Depends. Well, we should finish this witness this afternoon, I would think, this evening. Cross-examination. I think here he comes now.
Yes.
Can't hear you. You need to turn your microphone on, Mr. Fakran. Still can't hear you.
Good afternoon. Can you hear me?
Yes, good afternoon, Mr. Fakran.
Good afternoon, Your Honor.
Yeah, good afternoon. Mr.
Good
Fakran,
afternoon, everyone.
can you come to page 530 of the old bundle? 530.
Yeah, sure. Yeah, I'm there.
Okay, so move on to page 531. Please confirm your name and passport number. And
Your Honor, I'm sorry to interrupt.
I need to affirm, I think.
Just pause a moment.
Can you please confirm to the court whether you would like to swear in by oath or by affirmation?
Affirmation.
Can you please confirm your name and occupation for the court's record?
My name is Mahmoud Fakran, and I'm a director at SPL, Snyder Prime Limited.
Please repeat after me. I affirm that I will say nothing but the truth.
I affirm that I will say nothing but the truth.
Thank you.
Thank you very much. Thank you, Alia. I'm
Thank you.
sorry I did not give you a hearing immediately. So there we are. You're affirmed, and Mr. Ghosh will just ask you to prove your witness statement now, which you should have in front of you, I think, at page 530 of the bundle. And
Sure.
I hand over to Mr. Ghosh to do that.
So please confirm this is your correct name and passport number. In the
Yes,
first
it
paragraph.
is.
Confirm your signature at page 535.
That is my signature.
Please confirm whether the facts stated in your witness statement are true to your knowledge and belief.
I do confirm.
Yes, so we are submitting this evidence, Your Honor. Mrs. Asha, this is your witness now.
Thank you very much, Mr. Ghosh. Mrs. B. Joy, yes.
Mr. Fakran, would you agree with me that as per records, you were appointed as a director at the first defendant on the 15th of November 2023?
I do agree, yeah.
Why do you believe the first defendant, who is currently in dispute with the first claimant, would hire you, considering your previous position as a director in the first claimant?
How can he speak for the mind and intentions of another person, Mrs. B. Joy? You might ask him, is there any particular reason why he was employed? What job he applied for?
Yes, Your Honor.
Things like that. But you can't ask him to speak as to another person's mind.
Yes, I will be rephrasing the question, Your Honor.
Thank you.
Do you believe that the obligations under a contract are to be complied with?
Which contract?
Any contract.
Should be.
Do you recall the terms and conditions outlined in your employment termination agreement, which you will find on bundle, page reference number? If you could please hold on a minute, I will just locate that document. Your Honor, apologize for the delay. I'm still locating that document. If you would, Honor, please allow me to take a few minutes.
Yes, certainly.
Your Honor, I saw that termination letter in the bundle when I was reviewing the file, but I'm not able to locate that for some reason. I'm still locating that. If someone can assist me with the page numbers, I think that would be really helpful. Although, it is onerous request to ask.
What is the purpose of this line of questioning?
There were some restrictive clauses as per the termination.
Right. Okay.
Yeah, so it is important that I ask him specifically on those questions.
Very well. Well, you need to find it then.
Or maybe I will move on to another question while my team can locate the...
Ms. Asha, it's page 404.
Thank you very much.
404.
Starts from 403. I think it's the evidence of Mr. Garg. That's what you're referring to, right? And probably the exhibits will be there along with it. I'm not sure whether I'm right now because I cannot find the exhibits.
No, I don't think so.
417, I think it starts.
Yes, 417.
Of the old bundle or the new?
Old bundle, of course. It's the employment contract.
No, I'm referring to the termination letter. There is a termination agreement, and I remember reading that. That's just the one that I'm looking for. Okay, I got it. It's on page number 420.
Okay. Yeah, it's a continuation of that, I think, yes.
Yeah, thank you so much. Yes. So my question to you is, have you gone through the terms and conditions of the employment termination agreement, which is found on bundle page number 420?
Yes.
On the confidentiality.
Which clause is that?
There is no clause number, Your Honor. It's under clause number 1. It's on page clause number 2.2. Sorry, clause number 3. Under the heading employee's obligation.
Yes.
Yeah.
So I just wanted to reconfirm whatever you have stated in your witness statement. Is keeping in mind your obligations under this termination letter in clause 3.
I believe my obligations are very clear here. If you look at point 3.6, so I can be also available for the company or the group of companies in terms of any administrative, regulatory, judicial, or judicial proceedings. So I believe SPL is one of the group of the companies.
Sorry, which clause are you referring to, Mr. Fakran?
The same one, employees obligation, point 3.6.
3.6.
Can you also refer to clause number?
Sorry, just give me a moment to read it.
Yeah.
And you're saying, Mr. Fakran, that this clause 3.6 entitles you to give evidence on behalf of the defendants in this case?
The company or the group of companies, which I believe SPL is one of the group of the companies as a shareholder of Sam Precious Metals.
I see. Well, these are not matters for me to determine. You're raising this, Mrs. B. Joy. Where is it leading? Are you going to make an objection to the admissibility of this entire evidence of Mr. Fakran?
Yes, Your Honor, because I would also be asking or referring Mr. Fakran to another clause in the termination agreement, which is clause number 5, subclause number 1, E and F, which prevents him from participating in any proceedings. Against the group.
And why?
I believe.
Wait a minute, Mr. Fakran. This is a legal matter. Why did you not raise objection to the admissibility of this statement when it was served long ago? You're doing it now as you're about to cross-examine the witness.
We will be making submissions on that, Your Honor, in the closing submissions, and I think it is already covered in our reply pleadings. Reply witness statement also. We would not make a specific proceeding for that, but it is covered under the reply witness statement of Mr. Anuj Garg.
I'm aware that this bar has been raised, this objection to Mr. Fakran giving evidence. But why has the court not been asked to determine it as a separate, discrete issue? It seems to me now that what you're contemplating is you're going to allow the evidence to be received by me. You're proposing to cross-examine on the substance and merits of it. And then you're going to submit to me that I shouldn't be entertaining it at all because it's in breach of a contractual obligation of Mr. Fakran. This is absolutely unheard of. One sees things, objections in witness evidence, even in pleadings. But if there's a point to be raised, a legal point, this is a pure legal point concerning the admissibility of this evidence. And you're now seeking to take objection to this evidence, but at the same time allowing it to be led before me and then cross-examined to it as well. This is not the way to go about things at all. Well, so what do you want me to do? Do you want me to hear legal argument now as to whether he's entitled to give evidence or not? Or are we going to go through the pantomime of me hearing you cross-examine him on the contents of his statement, which on your version of things, he should never be giving at all as evidence in the case?
Yes, I will not be going into the cross-examination, Your Honor. I would just be asking these procedural questions and we'll be resting the case and to your decision, Your Honor, in the final closing submissions. Our position is that he should not be heard. These evidence should not be on record because of the express breach of the employment termination letter.
And you want me to decide that when I come to weigh and consider his evidence as a preliminary point, when I'm sitting there writing my judgment, you want me and making my decisions, you want me to step back from it, consider the legal objections that have been made to the giving of the evidence and reject it. So tell me what happens in these circumstances. Say that I'm against you and I consider his evidence to be admissible and I take his evidence into account, find it to be acceptable, convincing, and you haven't challenged it at all. Where does that leave me? It's not been cross-examined to. Do you not see the absolute absurdity of the line that you've taken here? Raising this legal objection at this stage, telling me that you're not going to cross-examine on any of the substance of his statement, and then leaving it to me to decide whether you are right on the legal objection you raise and disregard his evidence and his statement if I agree with you, without contemplating for a minute what I do if I reject your legal submission, just no thought has been given to that situation. Would you like to reflect on it for a moment with your instructing
Yes, Your Honor.
clients and counsel, and ask them what the question I've asked you? What am I to do if at the point when I come to consider and weigh this evidence with all the other evidence in the case, I find myself saying, well, I don't agree with this legal submission. This is a witness who's come before the court to tell the truth, and he's been lawfully called, he's been lawfully asked questions, he's given his answers, he may be in breach of contract, but what I have to decide is whether he's telling the truth or not.
Yes, Your Honor. So if I may take a recess of 5 minutes, I will just talk to the instructing counsels and be with you on the approach.
I'll give you 5 minutes, certainly.
Thank you very much, Your Honor.
Yes, Mrs. Bejoy, how do you wish to proceed?
Yeah, yes, Your Honor. So I have taken instructions from the counsel and from the client. So they would like to continue with taking the evidence of Mr. Fakran. What had happened is Mr. Fakran's evidence was more towards before we were splitting the case. And therefore, we would not be having many aspects that are relevant to the current case. However, for the completion of the evidence, we are happy to proceed and continue with the evidence as it exists. And I will have a very few questions to be raised to Mr. Mohammed Fakran.
You mean you're going to cross-examine him on the contents of his statement, which support Mr. Shakti Chauhan's evidence and the defendant's evidence that the necessary 200 kilograms of gold were supplied by the various means that he has described in his statement. You're going to deal with that in cross-examination, are you?
Yes, Your Honor.
Right, but you're entitled to maintain your objection that I should disregard his evidence anyway, and I will consider that. But I cannot be left, as I've just explained to you, in a position where this evidence is before me without it being challenged. If it is to be challenged, which I think I'm entitled to assume it would be challenged, and it is not accepted. Right. Very well. Begin your cross-examination then, and you can make your legal submissions in your closing submissions as to why I should not pay a moment's heed to anything he's written or will now say in giving his evidence. And I will consider that in the light of Mr. Ghosh's responses to those submissions.
Yeah, much obliged, Your Honor.
Right.
So, Mr. Fakran, if I may please refer to paragraph number 10 of your witness statement, which you will find on page number 533 of the old bundle.
Yeah, I'm there.
In paragraph number 10, you refer to non-binding nature of the MOU. Would you agree with me that at the time of signing of the MOU, you were not employed either by the defendant or by the claimant?
I was not employed, but I was included in the all the discussions and conversations. And also I have been asked by Mr. Sami also to help him to find, even before that, some investors or people who would be interested in investment in a refinery. So I have been involved, especially from Mr. Sami's side.
So you were representing Sami in the MOU? More involved from
involved as somebody from the market, as a friend or colleague from the market, and again, as I said, upon his request to also support him and help him in finding some investors from the market to proceed with his project.
Right. So apart from Shakti, did you manage to speak to anybody else regarding the investment requirement of Mr. Sami?
You mean before he signed the MOU with Mr. Shakti?
Yes, before signing the MOU.
Yeah, so before I was working for a company called MEK Global Trading, the MCC. So, and this is where Mr. Sami asked me if I can speak to the owner, which I have done that. And the owner showed interest in having a refinery in Dubai. But as mentioned in my statement, due to the points that Mr. Sami didn't agree, like any investor would have at the end of the day an overview about his investment, what's going on, what's happening, overview about the operation. So Mr. Sami was against that access to this investor, so it didn't go through.
Right. Okay. So can you tell me what was Mr. Sami's requirement for a potential investor?
What do you mean? Can you be more specific?
My question is, you said that you have been looking for investors for Mr. Sami.
Okay.
So I'm asking you, can you please tell me, according to you, what was Mr. Sami looking for in a potential investor? What was the requirement of a potential investor?
In what respect? There could be hundreds of different respects. Will you be more specific, please?
Yes, Your Honor. In terms of the investment and in terms of other contributions.
It was not specific, to be honest. Then at that point, Mr. Sami had the idea of starting this venture, but he didn't have the investment. So anything which can support for this project in terms of investment was acceptable. The only thing which he didn't accept to have access or even like management overview, or control over the daily operations.
According to you, how much was the investment Mr. Sami looking for? Any idea?
Well, to be honest, from my ex-employer, MEK, at that point, what was presented or the interest that they have showed to invest 4 million. And this was my question to Mr. Sami back then when he started at least this joint venture or the partnership with Mr. Shakti, that he agreed on the 2 million initially working capital. So that's what I'm saying. It was not specific what is needed. I believe most important for Mr. Sami that nobody interferes in the management.
Right. Okay. Were you aware of any gold working capital requirement?
In this MOU or in the previous one?
No. From what Mr. Sami was looking for in a potential investor, whether the requirement to have access to gold working capital, was there a requirement like that?
See, in my discussion when I was involved with my ex-employer MEK, it was not required. But when upon agreeing with Mr. Shakti, he informed me that there would be 200 kg working capital injected in the company.
Okay, so you confirmed to me that as per the agreement between Mr. Sami and Shakti was to bring 200 kg gold.
See, the MOU is clear. Now it's for us, we see it non-binding. It's up to this honored court to decide it's binding or non-binding. But yeah, the 200 kg, as we mentioned even in the previous hearing, Mr. Sami wanted to have, and I can to have when the draft was shared, he wanted to have undertaking on that MOU, where it was rejected by Mr. Shakti, and that's why it was called gold advancement. So, but in general, the 200 kg, was there. It's clear actually.
Can you tell me more about this undertaking? What is this undertaking all about?
Mrs. Bejoy, I have to interpret the MOU as it is written, not on the basis of pre-contractual negotiations.
Yes, Your Honor.
Unless you tell me that there's some different rule applies in Dubai, this is this reference to pre-contractual negotiations is of no benefit to me in interpreting the terms of the MOU and what they mean. And you'll be arguing, no doubt, that advancement is the same as an undertaking. Mr. Ghosh may be arguing something different. At the moment, all he's alluded to is that it's not binding, which I will have to decide. I don't see a lot of profit in examining, therefore, in cross-examination, various debated forms of wording for the MOU. I have to interpret the one that was arrived at.
Grateful, Your Honor. I will just move on to my other questions.
Yes, please do.
Mr. Fakran, I would now like you to refer to paragraph number 4 or 14 of your witness statement.
14.
Yes, Your Honor, which is on page number 534.
Yes.
And you state there that the defendant number 1 had arranged financing of amount 5,904,587 as confirmed by the finance manager of the claimant number 1. You also refer to an exhibit and email dated 12th of February 2019. Apart from this email, is there any other document that shows the contribution of 5.9 odd amount million?
Well, it's mentioned in the financial statement, the annual financial statement of 2018. And along with that, and this is here, I'm only talking about the currency arranged other than the 50 kilos arranged from Al-Shahir. And if I take you to page number 792 from the annual financial statement of 2018, you can clearly show convertible loans, gold loan, which is the 49,750, currency loan related party, which is coming from directly from Snyder, 1.041, and currency loan third party, 4.9, which is coming from Al-Asil.
Sorry, where do you say the first one is coming from? The gold loan from third party?
This is Al-Shahir, Your Honor. Al-Shahir Jewelry.
Sorry, can you spell that? There are some similar names here.
Yeah, it's the same. Al-Shahir. Al-Shahir.
Shahir. Thank you for pronouncing it. So the evidence before me is that that loan was received on the 31st of December and was repaid on the 5th of January 2019. And you are telling me that is that was part of the 200 kilograms of gold that, subject to it being binding or not, Snyder Prime was required to invest in the first claimant, Sam.
Yes, Your Honor.
You're nodding. You're telling me that's part of the investment that was required under the terms of the MOU, paid on the 31st of December and returned on the 5th of January. That's what you're saying. It's part of the
Yes,
investment.
Your Honor. Yes, Your Honor. And
can you just answer me this question as well, please? Just bear with me 1 second.
sure.
You say that you are familiar with the terms of the MOU. You were involved, or at least aware of it being negotiated. And you referred to this dispute about whether it should be undertaking or advancement of this capital. Does that comply with the requirement that it be in the company for 5 years?
See, that's true, Your Honor. So any money which was arranged by SPL, the intention is to keep it for, according to at least the MOU. But I believe when the STA came in Feb 2020, it has replaced the MOU. But in 2018, 2019, at least, I would say, especially during, since I was still there, I can confirm 100% that this money and gold were still there. And whatever has been mentioned about...
Sorry, was still there?
Yeah, 2018.
So you're telling me it's not true that it was repaid 6 days later, 6 days after it was paid?
Well, for whatever excuses that have been mentioned that it's repaid, it was not the case, to be honest. It was still there. And the promissory notes, when we signed it in April, it is a big evidence that it was still there. There is no any reason for any accounting purpose that has been mentioned that you have to create this promissory notes if they were repaid 5th of January. So a statement, regardless of what has been or had been mentioned, a statement of account is enough to show that it has been paid. But as long as, and the facts are clear that this email has been shared by Mr. Dino on the 2nd of April of 2019 and signed by me and Mr. Sami and has been or have been put in the files and the safe of the company.
But I've also been, there has been produced before me an accounting record of the repayment of this money by Sam Precious Metals at a time when you were working for Sam, an accounting document which shows it coming into the company on the 31st of December 2018 and being paid back on the 5th of January 2019. Are you telling me those documents have been fabricated?
I do agree, because...
I'm sorry, are you saying they've been fabricated?
I do agree, it has been. See, at the end of the day, Your Honor, they have the control of the books and the system. The system can be accessible at any point by a couple of authorized people from the company. Again, till my exit, I can confirm the money was still there. And what we have proven that these promissory notes has been shared in April, signed in April, which means clearly that the money was still there. And again, I'm saying, for any accounting purpose, it doesn't make sense that you have to issue a promissory note to define or to justify something in the past.
Did you hear Mr. Skandalis give evidence this morning?
Yes, Your Honor.
And he, you presume, you would say to me, was lying to me, was he?
Yes, Your Honor.
Right. Thank you very much. Mrs. Bijoy, you may continue.
If you allow me, Your Honor,
yes.
Because all these promissory notes in the previous hearing were clearly mentioned from all the witnesses from the claimant's side that it has never been signed or have never been signed. Because the fact, or at least the feeling they had, that we don't have access for any information. Luckily, I would say it was a miracle to get these documents, knowing how many years have passed now since we have exited SAM. So, but if you go back to the previous hearing, all the witnesses have stated that these promissory notes were not signed. That's why, which means the money didn't come, which to me personally, it was a shock, actually, like to hear such statements.
So Where then is this money shown in the company still at a time when you were there in the following year's accounts? Where do we find that in the financial statements as at the end of 2020, it would be, wouldn't it?
Well, as you can see, Your Honor, the promissory notes talks about at least 1 year, so it should be till the end of December 2019. So means if it is paid by the end of December, it wouldn't show, in my opinion, in the financials.
So it isn't shown, if I'll be corrected if I'm wrong, as a convertible loan for which the company is liable in the financial statements as at December 31st, 2019. Is that correct, Mrs. Bijoy?
If you take me as well to the 2019 financial statement, I would have also, we can have a look together.
Right, that's council's duty to do that. No doubt she will.
Your Honor, definitely. I have a couple of follow-up questions on the statements that Mr. Fakran just made.
Right,
yes,
very well.
If you may please allow me to.
I most certainly will. I just wanted to an answer to those questions for myself, as they obviously arose from what evidence has been placed before me and that I'm considering. And I have this witness's evidence now about it, that there has been a fabrication of evidence by persons unknown with control over the company's records to present a false picture to the court of this money being repaid on the 5th of January 2019, which is not true. And furthermore, the witness has told me that this money is still in the company. That's right, isn't it, Mr. Fakran? That's what you've just told me?
Yes, Your Honor.
Thank you.
Yeah.
So, Mrs. Bijoy, now that we've clarified precisely what this witness's evidence is on this very, very important matter, you may ask whatever questions you want in relation to it.
Yes. So, Mr. Fakran, I would like to refer you to the new bundle, page numbers 90.
90.
90, yes. Are you at page number 90?
Yes.
You agree with me that this is a tax invoice issued by Al Sahir Jewelry?
I saw the invoice, yeah.
And the weight.
Is it uploaded on the portal of the tax authority?
Sorry, come again.
Is it uploaded in the portal of the tax authority?
This is uploaded in the. You are saying or you are asking me?
I'm asking. I'm not saying.
Well, you don't ask questions, Mr. Fakran.
Oh, I'm sorry.
Just answer the questions you're being asked about it.
Sure.
And you confirmed it's a tax invoice from Al Shahir relating to the gold that we're talking about now, 31st of December 2018.
Yes. And do you know the implications or when a tax invoice will be generated? That is a question.
I didn't get your point. I didn't get your question.
A tax invoice would mean that the concerned entity would be liable to pay whatever tax to the authorities. So every likelihood that this would be a genuine document. Would you agree?
That's why I raised the question, although I was not allowed if it's uploaded on the portal. If it's uploaded, then I agree.
Right, I get your point. Okay, let's move on to the next document, which is document number. Page number 91, again, another tax invoice from Al Sahir with a VAT number. And the date is 5/1/2019.
Yeah.
And that is issued And the transaction type is metal received voucher.
Yes.
And that has the signature of both Sam and the signature of Al Sahir Jewelry and the company stamp.
Yeah.
So metal issue and metal received.
Yes.
Out, out and in, as it
yes,
were.
Your Honor.
Out from Al Shahir and back in to Al Shahir.
Al Shahir.
Yes. Go on,
And
next document.
The next document is page number 92.
Yes.
That is a metal delivery, payment delivery issued by Sam Precious, dated 5th of January 2019.
Yes.
And that also records pure weight grams 49,750 and the remarks repayment of 50 kg 995 against gold advance towards the end of the delivery receipt note. So you're saying that yes,
sorry,
Your Honor.
carry on. Yes, carry on with your question. You are saying?
Yeah, so my question to Mr. Fakran is, are you saying that all of these documents are not correct documents or falsified documents?
See, according to my knowledge and according me being one of the directors in the company back then, these documents were not there till the time that I have exited. No such transactions happened. And that's what I'm saying. I'm referring about the promissory notes, which have been signed in April. These were the only documents that I'm aware of to confirm the receipt of the 50 kg from Al Shahir back in 2018, 31st December.
So are you saying, straight question, that these documents showing the return of the gold to Al Shahir have been fabricated by the claimants, somebody at the claimants?
Looking at the documents, Your Honor, I would say yes, especially like just by looking at the documents. It's just so the letterhead of Sam, it's just like looking at page number 92. It's letterhead of Sam showing metal payment, metal receipt voucher. But again, what I'm confirming is, according to my position in the company as a director of the company back then, I had no idea about such documents that have been, or even such a transaction that happened, that we have returned the money that we received from Al Shahir in 5 days.
Okay. I would request you to please confirm if you were challenging the documents found on page number 90, 91, and 92. Does that mean that the document that evidence gold coming in is also a fabricated document?
No, gold came.
Okay.
The gold came from Al Shahir.
So that document is a valid document. Only 91
no,
and 92 are falsified documents.
See, what I'm saying, I've been relying to the financial statements, okay, where we were discussing what the 50 kg represents. The gold came from Al Shahir. I'm not denying that, of course.
And this is part. And document
evidence. Don't interrupt, Mrs. Bijoy.
Sorry.
Finish your answer, please, Mr.
So yeah, I'm not denying that the gold came from Al Shahir. Actually, it's one of the arrangements that SPL did. And by the way, just to mention that when the full 200 kg were completed, all of us as directors in the company, we were kind of celebrating and cheering up. But what I'm saying, what I'm debating, or at least I'm rejecting these documents that gold has been returned in 5 days. See, and to be more clear, if it was the case, I would I believe it should have been mentioned in the first hearing in this way. So when we showed the promissory notes, because the promissory notes back then were not signed, because we didn't have access to the signed promissory notes, the only challenge was like promissory notes were not signed or are not signed, which means this money never came. But once we presented the signed promissory notes, these statements came to the picture.
Okay. So if I take you to your own document that is referred in paragraph number 14 of your witness statement, you have referred to exhibit number MRF5, which is found on the old page, old bundle, page number 542 until 544.
MRF5.
Yes, Your Honor.
And the page number again?
542.
Thank you.
Until 544. Mr. Fakran, are you on that document? Do you have the document before you?
Exhibit M R5?
R5, yes.
And sorry, which page number?
Page number, I would like you to please refer to page number 543 and 544. I have some questions on that, please.
Yes, I'm there. 543.
So it is your position from paragraph 14 of your witness statement that this is the balance sheet of the company.
Yes.
A draft of the balance
Draft,
sheet.
yeah.
Can you show me where is the contribution from Al Sahir recorded in this draft document?
See, in this one, it's not showing. And again, it's a draft. Draft can always be changed unless if you are also challenging that the money didn't come on 31st of December. So it's a draft that has been prepared, shared with the directors. Back then, most probably the 50 kg of a share was not presented in this balance sheet, but definitely it has been reflected on the annual financial statement of 2018. And maybe here, because it's only dollar, there's no gold mentioned. Maybe that's the reason. But again, it's a draft, and most probably something that the gold was not presented here. But I rely on the annual financial statement.
So if I go by your, yes, Your Honor.
No, it's all right. I want you to take me to the year-end 2019 accounts, because I want Mr. Fakran to comment on those. You were still with Sam at the end of 2019, were you, Mr. Fakran? When
end
did
of
you
2000, July 2019.
July 2019, I see. So I think I'm right in saying that in the year end 2019, I don't have the particular reference to hand at the moment. Perhaps somebody could give it to me.
Yeah, it's on page number 800, Your Honor.
800. Thank you for that. Thank you for that. Then Mr. Fakran can answer my question that's troubling me. So we see in these accounts which page is it, Mrs. B. Joy, where
800 of the old bundle, Your Honor. That is the balance sheet for the financial year ending 2019,
Right.
December.
Right. Yeah. Just let me find the figures that I've been directed to before. So we looked at the convertible loans, 4.9 million. That is the financing arranged by Snyder with Mr. Garg's assistance from the name of the company, so many companies.
Al-Asil, Your Honor.
Al-Asil, Al-Shahir and Al-Asil we're talking about. So this is from Al-Asil. And then we have the 1,041,000 convertible loans above, which is from Snyder itself. And then there's this figure of 2,046,817 that is in the accounts for the year ending 2019. And then we need to look at note 16, if my note is correct.
That's on page number 817.
817, I'm just getting there. And there we see advance from third party.
Yep.
And your case, Mrs. Bejoy, is which third party is this from? What is the claimant's case on that?
I think it would be helpful if we could get clarity from the current witness, Your Honor, because I don't remember what was deposed before in the previous depositions by the claimant's witnesses.
Well,
I would say if 2019, according to the promissory notes, if the gold from Al-Shahir came to maturity and it was repaid, it will not show here. This, in my opinion, or to my belief at least, this is from Vingold, because first Vingold invested 50 kilos through Snyder, which was injected in SAM. Again, this was denied in the beginning in the first hearing, but now it's been confirmed. We reached to the expiry of the agreement by August, and then it got renewed for another 6 months. The only thing, instead of gold, he invested cash or US dollar. And this was coming in a way, Vingold Imperial SAM. So this is the structure that has been agreed, and this is where it has been stated, I believe, in this hearing as well, about the renewal of Vingold investment. But instead of...
Yes, I understand you now. So your position is that this figure here is, as it were, the continuation of the Vingold investment, which ended in August. You're saying that was continued with another party involved, Imperial, rather than Vingold. Is that right? Very well. The question I'm trying to ask then is, if that's to do with Vingold and the successor Imperial, where do you say the Al-Shahir investment that you say has remained in the company and has not been repaid, and that these are all fabricated documents? where do I see that Al Shahir money in these 2019 accounts?
No, this is what I'm saying, Your Honor. What I said, according to the promissory notes, this gold had to stay till the end of 2019. And as long as it's not showing in the end of 2019 annual financial statement, means it has been paid and has been replaced with this 2 million cash that has been arranged from Vingold after the renewal of the investment agreement.
I'm sorry, I thought you said earlier that the Al Shahir money had remained in the company, had not been repaid, and that these documents
2019, Your Honor. Beginning of 2019, Your Honor, what I referred that this payment in 5th of January, it was not there. And according to the promissory notes, this gold investment had to stay till the end of 2019.
I have that point, but you told me earlier that this money from Al Shahir was still in the company. And I don't see it in these accounts for the year end 2019, or indeed subsequent to that. So where is it? Where is it shown, this money from Al Shahir, that you refute and make very serious allegations, about it? You refute it has been repaid. You've told me it has stayed in the company. Where is it shown in the company's financial statements as an asset, or I should say a liability?
This is what I'm saying, Your Honor. If it has been paid before the end of by the end of 31st December 2019, then it will not be shown in the annual financial statement of 2019.
Right. But are you now accepting it must have been repaid to Al Shahir, or are you adhering, or are you still saying it remains in the claimant company?
No, even according to the promissory notes, it's mentioned the maturity is 31st of December 2019. And always the intention of SPL is to keep arranging investments or funds in order for the refinery to keep generating or at least buying and selling gold, because the refinery needs gold. At the end of the day, you need gold to make the refinery work. So, but what I'm saying is, even according to the promissory notes from Al Shahir, what I am debating, or I did not accept, that this money was repaid 5th of January 2019.
All right.
I'm not disputing that this money could be repaid by 31st of December 2019, and that's why it's not showing in the annual financial statement.
Right. So you wish to retract your answer earlier given to me that this money is still in, the Al Shahir money is still in SAM Precious Metals. You accept it's been repaid at some stage, do you?
By the end of 2019, yeah, I would say, according to the financial statement of 2019.
Very well.
So at the end of the day, Your Honor, what I stated as well, that till my exit in July, I would 100% confirm it is there. And this is my debate was in the beginning, that 5th of January 2019, that transaction was impossible that it happened. But the promissory notes are even clear that the maturity of these notes are 1 year, starting 31st December 2018, ending 31st December 2019. And I'm referring to the annual financial statement of 2019. If this gold was repaid before the 31st of December, it will not reflect here. Well, what is reflecting here is the renewal of the agreement, Vingold, Imperial, SAM, whatever, which shows as a currency $2 million.
Very well. I have your evidence on that. Thank you very much. Mrs. B. Joy, would you like to continue? Is there anything else?
Yeah, just one follow-up question on that, Mr. Fakhran. So Al Shahir, according to you, should have been paid by or got paid by the end of December 2019. And that is why it is not reflecting in the 2020 annual financial statement. So do you agree with me that it was for a short term of maybe 1 year and not more than that, and therefore it would not be a working capital contribution as it did not stay for a term of 5 years.
See, there is a lot of confusion created about this 5 year. The most important thing is this 200 kg should be there every year. Now, if you get investment from a certain party and it's been specifically all the time mentioned, it should be 5 years. There is nothing, even if it's the 5 years is the working capital, the 200 kg. It doesn't state if I receive money from X party, that investment or that agreement should state 5 years. As a non-binding commitment, you know, my responsibility as SPL is to keep every year 200 kg shown in the books of the company. And to me, it is clear that every year there was 200 or 200 plus of kg of gold with SAM Precious Metals. So the confusion is about 1 month, 1 year, 5 years. It's just to create confusion, to be honest, in my opinion. As long as the company has the gold under their utilization and under their supervision and management, then this is the main thing. It's I can do agreements tomorrow. I can sign an agreement and then tomorrow something happens, then that agreement should come to closure. So it's not even guaranteed, you know, like that everything has to stay 5 years agreement wise. But the intention is to keep the capital or the working capital with the company every year, 200 kg and 200 kg plus was always arranged for SPM.
There we are, Mr. Fakran. That is the issue that I have to decide. Whether it was, as you have put it, capital that was from various different sources and replaceable, but in total 200 kilograms or more, or whether what was required was a 200 kilogram investment by Mr. Chauhan, or by Snyder Prime. We're talking of people here, but Snyder Prime, 200 kilograms upfront, remaining in the company for 5 years. That is the issue I have to decide. Very well. Mrs. B. Joy, is there anything further that you can cross-examine to?
Yes.
On this?
I'm nearly done, Your Honor. Just one last question.
Yes.
So, Mr. Fakran, you have confirmed that you left. When did you say you left SPL?
July
2019.
Okay, so you confirm to the court that you have left SPL in 2019. So you wouldn't know.
SPM.
Sorry, sorry about the mistake. Yes, so you wouldn't know what has happened afterwards your exit. You would not be in a position to say about the state of affairs after your exit.
And that's why I'm stating whatever I have examined and witnessed and read, I'm confirming. So whatever I have confirmed means according to my knowledge, from my own knowledge from before, or even from documents that I have examined and read and clarified, whatever.
How did you get possession of these documents after your exit? Get access to these documents of the SPM?
Which kind of documents you're talking about?
Whatever documents that you have relied on for the court purposes, how did you get to see those documents?
If you can specify a document, maybe I can refer to them.
It's quite clear. All of the documents that you've referred to in your statement and in your evidence, which are SAM documents, its accounting documents and so forth, that have enabled you to give the evidence and the view that you've given about what happened after you left in July 2019, which is your whole case and evidence, that this 200 kilograms of capital was, if you like, a moving feast. It was coming from different sources. It was being replaced, and at all times through the period of 5 years, there has been this requirement fulfilled. Where did you get the documents that have enabled you to give that evidence to me? That's the question you're being asked. Where did you get them, or did you retain them? Did you take them when you left, Sam?
So whatever WhatsApp conversations or email communication, or even what has been shared earlier from the annual financial statements that have been provided, because knowing that even the defendant didn't have access to the annual financial statement. So from these sources, so WhatsApp, emails, communication, and annual financial statement shared by the claimants.
Very well. I have your answer then. Thank you. Yes, Mrs. Beju, anything else?
I don't have any other questions, Your Honor.
Right. Mr. Ghosh, do you have any re-examination?
No re-examination.
Thank you very much. Mr. Fakran, thank you very much. Your evidence is complete. You may leave the screen and
thank you, Your Honor.
We're going to finish. We're going to finish for today in any event. Now it's 5:30 in Dubai. So thank you very much. You may leave. Mr. Ghosh, I am deeply, deeply troubled. I've heard evidence this afternoon of a scheme of fabrication to conceal or to invent the repayment of an investment 6 days after it was made. And none of this has been put to any of the claimant's witnesses. You must accept that it should have been put. You must have been aware of what is being suggested now by this witness. If you were not, please tell me so. I'm not prying into privileged communications at all, but it troubles me deeply about how I am going to deal with the fact that this was not put. These very serious allegations were not put to the claimant's witnesses when they were giving evidence. I am not going to allow a further recalling of the witnesses, but you should be on notice that the court may draw an adverse inference as to whether what I'm being told today in evidence is credible. You understand?
Yes. I'm putting across the bar. Yes, I was not aware of this statement which Mr. Fakran made, and I never instructed, and it was never discussed. I never instructed them also, and it was never discussed with the clients also, that we will make a statement relating to fabrication or challenge it on the ground of fabrication. Otherwise, yes, documents were staring at my face. I could have easily asked some questions, which I did.
Precisely. Well, I didn't specifically didn't want you to go into privileged communications, but the position is now clear. Thank you very much indeed. And on this occasion, you are obviously not at fault if you knew nothing of what has been said before me today in evidence.
If I knew, at least I would have put up a suggestion. I didn't put up a suggestion also. So
thank you, Mr. Ghosh. Then absolutely nothing in the way of any criticism can be attributed to you in relation to that matter. I will have to assess the witness's evidence in the light of the fact that this comes in the way it has come out before the court.
yes,
forgive me perhaps for even contemplating that might have been the case, but you'll understand, having regard to what has previously happened about things not being put,
yes,
that I was concerned in case something you're aware of had not been put. But that is not the situation in regard to this, and I'm grateful to you for clarifying that to me. Thank you.
I'm also grateful, Your Honor, taking up for asking me this actually. Yes.
Mrs. B. Joy, I think that's all we will do for today. So I need to ask you now, what is the position with regard to the expert witness?
Yeah, yes, Your Honor. So I have been told that the expert would be available tomorrow afternoon at 2 p.m.
Right. So the bottom line is we cannot start then until 2 p.m. tomorrow. There's nothing
Yeah.
else. There's
Yeah,
nothing
there is
else.
nothing else that we have to do, Your Honor. Yes.
Right.
In fact, I was confident that everything would be over by tomorrow afternoon. I mean, I didn't know that expert would be here, but it's good that
Right. Well, it will be over by tomorrow afternoon. The expert it will simply be cross-examined by you and then re-examined. I may have some questions of the expert about the accounting documents that he has relied on. But if I have questions to ask, I will give you both an opportunity to come back after I've asked those questions to seek any further clarification that you consider to be necessary. So we'll leave it at that until 2 o'clock tomorrow afternoon. And I wish you a good evening and good day to you.
Thank you.
Thank you very much, Your Honor.